Oh, we did.
Item number 1.
Wait, but on the last occasion, the interlocutory application was filed on behalf of the contractor, seeking a direction against the state that their work should not be terminated before the extended period. That was dismissed. And accordingly, today the state was directed to file the status report. Yes, status report. If your lordship permits, may I?
Let us see the status.
Nothing has been moving in the last 2-3 months.
After the contractor's admission that the work has become impossible for completion up to 31st of July, we have initiated to terminate them by giving a notice for termination. In the meantime, they have approached the learned district judges under Section 9 of the Arbitration Act, and they have obtained a stay order.
What was it?
That was on 5-3.
5-3. What have you taken thereafter?
We have today. We are going to file our objection to that for vacating the interim order.
Let us see that order. Have you included that order?
My lord, at internal page, my lord, it will start from
Is it there in the compilation?
yes, my lord. Page 71 onwards, my lord. This is miscase, my lord. And the order will be at page 73. Operative portion will be at page 82. Starting from page 81, para 17.
Mr. Dubey, what is your intention? Let us know what is your intention. You want to stall the thing forever?
No, Lord, that can't
Is
be,
it
Lord.
possible?
Lord, in fact, I have also advised my clients to come out.
You have advised your client to approach this with a Section 9 application. Is that your approach? You can take legal recourse, but we know how to deal with you. You can act very smart. But there are smarter people than you. But think in a holistic manner, what do you gain by stalling a process?
No, we don't.
This is going for years and years. Nothing is progressing, and you are stalling by Section 9 application. What is your intention? Let us know your intention very clearly.
But we also had our issues, not may I indicate.
Your issue would be resolved, would be adjudicated. But why do you stall it?
What has happened, Lord, our payments were not made. Lord, in fact, without terminating our contract, Lord, they have invoked the bank guarantee, Lord. They have encashed the guarantee.
Now, what is the nature of the interim order which you had prayed for under Section 9? You know the limited powers of Section 9. Courts are to be totally excluded in the arbitration proceeding. Only on exceptional circumstances you approach Section 9. After the amendment, everything will be taken care of by the arbitrator.
In fact, your Lordship would see, Lord, when we wrote to them, they themselves said, Lord, that in terms of the contractual terms, Lord, they have not complied with their obligations. That's why we had requested them for extension of
So,
time.
Mr. Dubey, you may have issues, technical issues, but we are dealing with a public interest litigation where the interest of the public is of utmost importance.
Paramount, my lord. I can
The,
dispute on
see
that.
the road, it's the same which has been on and on from the last so many years.
But can I make one request for your lordship's consideration?
The request is not
No.
corresponding with your conduct
No.
in approaching a section 9.
Lord,
You can approach, no problem. But you approach, we will also deal with in our way.
Let me give us a final opportunity, Lord. I'll have instructions from my client. I have also advised that there's no point stalling the work, Lord. And Lord, if we can't do it, Lord, it's better we surrender, Lord. That's
See, last time, if you remember correctly,
yes.
you had expressed your difficulty that this work cannot be completed within this period.
Fine, right.
So either it has to be offloaded, whatever expression is used, or something has to be done for getting the work completed.
That's correct. No, that has been recorded, but whether we can complete it with a categorical statement
No.
on our part, Lord, we could not do it, Lord.
There cannot be a stalemate like this.
Yes, Lord.
And who is the sufferer?
Yes, it's the public, Lord. There is no dispute about it, Lord. We also,
State
Lord,
is suffering.
officer of the court, Lord.
And where in the state, in this center of the state, in Naharlagun, Itanagar. Not some remote district.
Yesterday also I had a discussion with my client, Lord. I said, Lord, that it's no point continuing like this, Lord. Either we can do it or not. And in fact, Lord, our bank guarantee and all has also been encashed. So, Lord, one course of action I have suggested them that if any dispute is there, you continue, but you can't do like that with the work, Lord. But may I pray, Lord, may take it on 23rd of this month, Lord. We'll come with instructions so that not all issues are resolved on that.
You said you can complete this thing work. And what's happening now?
Lord, what has happened, Lord, they have encashed our bank guarantee. They have not been making us regular payment, Lord. That is the scenario. And Lord, under the contract, they themselves have admitted.
No, you go for take the recourse to that. We cannot stop it, but then we'll complete the work. We'll work it.
Your lordships, it has been a series of flip-flops on the part of the contractor. Your lordship will recall, in fact, your lordship was sitting. It was recorded on 26/9/2025. Before that, they were saying they don't have money to execute their work. On 26/9/2025, your lordship has recorded that now money, they have arranged the capital and are going to do it. And right thereafter, when the working season starts, all the affidavits, they say that the government is not paying money. Initially, rainy season, then said no money. On 26/9, your lordship has recorded that the capital has now been arranged, then they are going to proceed with the work now. It is on their submission, my lord. Thereafter, my lord, from October onwards, they say, this is on November, my lord, October onwards, they say that the government is not paying our money, they have withheld this and that. That is it. That is how the contractor has been going,
Mr. Dubey, we find lot of inconsistencies in your
After
conduct.
arranging, Lord, we have.
So you
infused,
come to the relief prayed for and the order passed by the learned judge at page 18. Page 18, the paragraph 18. You have the copy of the order?
Yes.
See, there are two aspects. One aspect is invoking the bank guarantee, which you have all the rights to hesitate in the appropriate forum, which perhaps you have done. And the second aspect is restraint from terminating the contract. That is absolutely inconsistent with your conduct. You had submitted before this court.
Yes.
A division bench you have submitted, then you turn around, you volte-face and you go approach the section 9 application and you say that kindly stay the order of termination. What is this?
With due respect, Lord, it's not that we have not indicated the order. Lord, we had also an example. Lord, our case was before the court, was that, Lord, we are entitled for extension, Lord, because of the delay in handing over the site, Lord.
That is not consistent with your submission made on the last occasion, recorded.
In fact, in the I also, Lord, we had made this prayer. Then your lordship has said that you must have to avail other remedy, not.
See, you cannot do the work. You yourself has said you cannot do it, and at the same time you don't want to be terminated. What is the way out?
Lord, your lordship would see him. Lord, we are also been handy.
What do you want?
Lord, we want to continue.
You want to just make money?
No, Lord, it can't be that way, Lord. If
then,
you don't work, I can't, Lord. Otherwise,
then you cannot work. You cannot complete the work you yourself has
my
said.
investments are also at stake, Lord. It's not, Lord, that
These are all consequences.
No, I understand what has fallen from your lordship.
For one individual,
It
the
can't be
state cannot
My lord,
suffer.
there
You're,
there
we
can't be
are
any
not,
second
we are not
opinion.
ignoring your legitimate
Well-
claims, which can be quantified in terms of money,
Well-
which you might get, you may not get. But how do you restrain a
Yes,
work
that-
being completed? And not for 1 month, 2 months, for continuously going for years together.
And my lord, my instructions are that after getting this interim order stay, they have withdrawn every man and machineries. Even the manager has resigned. Now they have obtained a stay order. They are neither continuing with the work. They have withdrawn themselves from the work also.
In any case, they have never been working. The whole winter season, well, the working season, there was absolutely no work.
We have. You come to 9(3) Arbitration Act.
I'm sorry, my lord, I have not the arbitration yet.
Do you have a copy? The court?
Lordship, I have already given the.
You take the court's copy. You read 9(2) as well as 9(3). See, after the amendment, the court's power and jurisdiction to pass interim orders have been made circumscribed. So come to 9(2) first and 9(3). See, we are not sitting an appeal over the order of the
In
court.
fact, this is one thing, we were expecting the government to move faster. They have not done it.
You did not even move, just see 2 and 3.
Yes. Well, before
They've
the
not filed
commencement
any
of the
appeal also, I don't
arbitration
know what's
proceedings,
going on.
The court passes an order for any interim measure of protection under subsection 1. The arbitral proceedings shall be commenced within a period of 90 days from the date of such order or within such further time as the court may determine. Once the arbitral tribunal has been constituted, the court shall not entertain an application under subsection 1 unless the court finds that the circumstances.
You have a very
Yes,
easy
ma'am.
remedy.
Yes, my lord. In fact, on 23rd,
You
when
initiate, you appointed arbitrator, let the proceedings begin. This will automatically become a
Yes,
surplus. And they will have the liberty to pray before the arbitrator. That's
Yes,
a
ma'am.
different matter. But Mr.
In fact, this was-
Of serious, yeah.
in fact, this was my advice also to the department. And department, they are also, the mode also is involved. So mode, they have some reservations. So before they have to, their advice is that we'll go first and file objection before the court, the district judge.
No, whatever you do,
My advice
your
was,
action should not even stall that you have taken this course and that course. Ultimately, who is suffering? The public is suffering.
public is suffering.
When are you approaching the when was this order passed?
On
5(3).
5-3,
Today is what?
6-4.
6-4.
1 month has gone.
Yes.
My lord, on this was fixed on 23rd. The matter was not listed in the course list. So the executive engineer was waiting outside, and later he came to know that the matter has been taken up. So another date, today is the next date given. Today we are filing. And in fact, there is a peculiar practice going on in the district court that only on the date of listing of the cases, the applications are being allowed to be filed.
Mr. Ratan, we are not here on an advisory
Yes, madam.
jurisdiction. You kindly say 37.
Yes, ma'am.
37 has been amended. 37, under
The
37, you can also file an appeal
Yes, ma'am.
against an order of granting or refusing to grant any measures under section 9.
Yes, ma'am.
You have all the recourse.
Yes, ma'am.
Those matters are not listed or whatever, you know what to do.
But, we are taking that,
When
action.
is the next date?
That's
It's today,
Today.
today, sir.
It's going on now.
No, it will be taken up today.
You have filed your objection.
Today, we'll be filing,
Today, if you
Miss-
file the-
yes.
they'll have some time to,
Yes.
that we cannot stop them.
yes.
But Mr. Dubey, advise your client, this is
But
not
I
how
have-
you,
but in fact, I had that talk.
you can drag a proceeding, but ultimately
No,
who's
Lord,
suffering?
that stoppage of work cannot, Lord.
You,
Now-
you advise your client, you restrict, confine your
My Lord, I
proceedings
understand, Lord.
to the aspect of monetary compensation, the bank guarantee invocation, whatever is there, but stopping the work without prejudice.
Yes.
Without
My Lord,
prejudice, why do you?
May I pray your lordship may take it on 23rd, Lord. Lord, on that day, Lord, I'll come with a solution on our side, Lord.
Yes, ma'am.
Heard Sri Deepangi, learned counsel for the petitioners. Also heard Sri N. Ratan, learned AAG, Arunachal Pradesh, as well as Sri R. Dubey, learned counsel for the respondent number 7. Full stop. This court has been informed that though a notice for termination of the contract along with invocation of the bank guarantee was issued, the same was put to challenge by the respondent number 7 in a petition filed under section 9 of the Arbitration and Conciliation Act 1996 before the learned district judge UPIA in arbitration ARBN dot number 1 of 2026, in which an order has been passed on 5/3/2026, in which an interim order has been passed. The interim order pertains to two aspects, namely restraining the termination of contract and encashing the bank guarantee dated 23/12/2020. Full stop. Para? We are, however, perturbed by the conduct of the respondent number 7, who had clearly submitted that under the present condition, it was not possible for them to continue with the work, and therefore approaching the learned district judge with a section 9 application, that too for restraining termination of the contract, does not seem to be done, is not at all in the interest of public. Para, be that as it may, Sri Ratan, the learned AAG, has informed that today is fixed, that the said case is fixed today, in which the state has filed objection.
Going to file.
State would be filing objection. Full stop. Sri Dubey, the learned counsel for the respondent number 7, has, however, submitted that some time be permitted, some time be granted to him to come up with a feasible solution, feasible resolution. Full stop. He prays for, he accordingly prays for and is granted time till 23rd of April 2026. Full stop. All further, the up-to-date updated status in the efforts arbitration case may also be apprised to the court on the same date.
Obliged, ma'am.
That's all. Yes.
May I please, my lord. My lord, today's item number 4, motion item, my lord. In the course title, instead of Public Works Department, I have mentioned the Rural Works Department. So, my lord, that may, before the matter is taken up, I may be allowed to correct it by hand.
How do
my
you correct?
lord.
Cannot correct by hand. It's now it's not possible. You file an amended cost ID.
My lord.
We can have it in the on Friday. If there is urgency, you can have it tomorrow also.
It's urgency, my lord. Urgency is there, my lord. So
But you need to file an amended.
I will do that, my lord. Okay.
File it, and whenever you file it, the next day we can have it. Thursday we can have it.
My lord, this may be hard today, my lord. In the meantime,
You can file it today itself.
today itself, I will try.
You file it, we'll accommodate, try to accommodate you in the second half.
Ma'am.
Okay?
Make this number. Madam, if it is convenient for your lordship, item 30, 31 and 32, maybe my lord upgraded if it is convenient to the court as per your lordship's convenience. 30, 31 and 32,
Contempt matters.
my lord.
We cannot just say, these are orders matters.
If it is convenient, my lord.
Orders, we can have it as first orders, but not before the admission.
31 and 32. Lordship, we were supposed to file objection in their IA.
Aye.
Yes. Lordship,
My lord, they have taken, this is the third time, my lord, these matters are coming up.
Okay, you be there when the matters are taken up. We'll not pass orders in the motion.
No.
Mention fees. But we'll have these matters as first items in the orders column, okay?
May I please, your lordship? Lordship, I beg to mention item number 25 on behalf of A.R. Barwa.
Yes.
Your lordship, due to some personal difficulties, he could not appear before this honorable court today.
25.
Yes, your lordship, item 25.
There.
Yes, his name is not reflected in court list, but in Wakalat
Okay.
is there.
A.R. Barwa.
Yes, your lordship.
Okay, when do you want this matter to be taken up?
It may be kindly be fixed on 4th May, your lordship. The Land Council is residing in Guwahati.
Okay, on a request made on behalf of the petitioner. Matter is adjourned to be listed on 4/5.
Yes, your lordship, oblige.
My lord, I'm mentioning item number 1 with the consent of the other party.
Yes.
The senior counsel, he couldn't make it today due to personal difficulty. With the consent of the other parties, your lordship, the matter may be fixed for 23rd April of this month.
On a request
One.
made on behalf of the petitioner. Matter is adjourned to be listed on 23rd,
3rd April, your lordship.
23/4.
Oblige, your lordship.
Hello. Lordship, I'd like to mention item number 26.
Yes.
The leading counsel is out of station in connection to his daughter's admission. So the matter may be fixed after 3 weeks.
On a request made on behalf of the petitioner, no, on a request made on behalf of Sri N. Tajid,
Yes.
learned counsel for the petitioners. Matter is adjourned to be listed after 3 weeks.
Obliged, madam.
Yes.
my lord, I beg to mention item number 18. I on behalf of T. J. Jambe, due to he is out of session due to health issue. So matter may be listed after 3 weeks. I have taken consent other party also.
On a request made on behalf of Sri J. Sering Ki,
Yes.
learned counsel for the petitioner. Matter is adjourned by 3 weeks.
Much obliged.
May I please, your lordship? Lordship, I look to mention item number 33, your lordship.
Yes.
I'm the petitioner here in this case, your lordship. As per the previous order, your lordship,
Yes.
this court has,
33 is connected with 32.
yes, so lordship, here in this case, your lordship, on last order, your lordship, this court was directed to fix the day, fix the matter after 4 weeks, your lordship. But it has been listed within 2 weeks, your lordship.
We'll see when the matter reaches. Okay.
Okay.
We'll accommodate you. We'll see the matter. We'll have to see the order sheet.
Obliged.
Please point it out when the matter comes up.
Okay.
Next.
Lordship, I beg to mention item number 35
Hmm.
on behalf of SK Diori, lordship. I have been informed that he has been recently in death. So matter
On the
may be,
petitioner.
yes. Earlier,
Request has been made. You want some time?
yes.
When?
Lordship, after break, lordship,
After
break, puja, vacation.
vacation?
Yes.
Okay. On a request made on behalf of Sri S.K. Dury, learned counsel, who has been stated to be recently engaged on behalf of the petitioner. The matter is adjourned to be listed after 2 weeks.
Yes, lordship,
2 weeks?
yes.
Yes.
Deeply blessed.
Yes.
Item number 2.
My lord, I am appearing virtual. I apologize, my lord. I couldn't travel to Itanagar, my lord. Some
No problem,
difficulties there.
no problem.
My lord, I will take my lord to straight away the order which I'm assailing at page 25. This is the order, my lord. 26, 24, my lord. Annexure 6. And the type copy is at page 26, my lord. Page 26.
Just a minute, please.
My lord, audit.
So your matter is presently
Yes.
before the Deputy Commissioner. Then
My
why
lord,
have you come?
my lord, let me just take 2 minutes to explain, my lord. Ordinarily, my lord is right. Ordinarily, we could have gone to the deputy commissioner challenging this order, my lord. But my lord will see the word in the second. My lord has gone through the second paragraph. It's the second paragraph. It says, after prolonged threadbare deliberations from both the party, the case has been settled by Kebang, my lord. The case has been settled. Can you mark the word settled, my lord? And my lord. My lord will come back to page 25 of that's the page 25, my lord. I just wanted to draw my lord's attention to the witnesses and also the parties here, my lord. Page 25, just the preceding page.
Yes.
My lord, all the witnesses in the left side are the members of the Kebang, and the right side are the parties, my lord. Yes.
What is your name? What is your name?
I'm Mr. Yobin. P. Yobin, my lord.
Mr. Yobin, this decision of KEBA 21/3/2026, you can challenge this in an appropriate forum. Why do you come to Red Court?
Yes, that's what I'm trying to explain, my lord. That's what I'm trying to. As I said, that ordinarily I could have gone there, my lord. Now, my lord, if my lord will come to the appeal provisions, my lord, of 2023 amendment, the Assam Frontier Administrative Justice Regulations Amendment 2023,
Yes.
I'd like
Yes,
to
please.
draw my lord's attention to section 9, my lord.
Yes, please.
Section 9, my lord, it says that any party aggrieved by a decision, my lord. It talks about a decision. Now, the Black Law Dictionary says a decision means a judicial or an agency determination. Now, the word that was used, which I'm assailing, which is ex parte assailing, is a settlement, my lord. Now, it's a very small order, but the potential and the danger of this settlement, my lord, is that my seventh generation land, my lord, the seventh generation, which has been in my family's occupation and enjoyment for the 7 generations, my lord, has been abruptly disturbed now. Has been abruptly disturbed. Thereby, my lord, my lord is very much aware that the privation of the property is not a fundamental right, but it is a human right
Mr.
and also a legal right.
Yobin,
Yes, my
Mr.
lord.
Yobin, come to the last paragraph of page 26.
Page 26, my lord.
Last paragraph.
Yes,
After the settlement, that the land stretched from so-and-so has been declared to be community land of Kima clan. No individual member
Yes,
shall be
Kina.
allowed to claim it.
Yes. So my
there is
lord,
a decision.
yes, I
There is a
don't belong
decision.
to, my lord, because this decision is coming on the unilateral settlement where they say that I was a party, which I am not, my lord. And I have also wrote a letter to the deputy commissioner. Page 23 is the deputy commissioner's, which I have written the complaint, my lord.
We'll not entertain this. You approach the appropriate forum. There's a direction after last part is the direction. There is a forum for challenging this. You cannot come to a writ court like this.
My lord, of course, I bow down to what my lord is saying, but the thing is,
We
my
are
lord,
not saying we are not expressing any opinion on merits. You may have a good case, but we will not
My lord.
entertain this. If you want, you can withdraw with liberty to approach the appropriate forum. Otherwise, we'll discuss.
my lord, I will withdraw with a liberty too, my lord. But in the meantime, my lord, kindly give me just that protection, my lord, till I approach the deputy commissioner. The status quo should be maintained. Otherwise, my lord, entire thing
What
will
kind of
become
status quo?
infractions for me.
What is the
In-
status quo you want?
My lord,
Do you
because
want to
now what
trespass upon
happens
the
that
land?
my lord, they are constructing the houses by trespassing into my private land, my lord. Just the status quo, my lord,
See,
till that. Otherwise, yes.
there is an order, no individual member shall be allowed to claim the mentioned proportion of land. This protection
my
is for all.
My lord, I don't belong to a Kina clan, my lord. I don't belong to the Kina clan, my lord. Now the Kina
Yes.
clan, another clan is entering into my property. That is what the danger is about, my lord. Just
3P, you
my
mean,
lord,
Learned
my
counsel
lord,
for
my
the
lord.
petitioners who have put to challenge an order dated 21/3/2026 passed by the, no, this is the order of whom?
My lord,
Who
this
has-
is a
who-
Keba of Dolumuk, my lord.
Passed by the
Kebang
Kebang, which
Board.
Kebang?
Dolungmuk. This is Kamle district.
Dolomuk in the district of Kamle. Full stop. It is contended that there is that the contentions of the petitioners were not taken into consideration, and an observation has been made that the matter was settled, which according to the petitioner is incorrect. Full stop. This court has, however, looked into the provision of the Assam Frontier within bracket Administration of Justice bracket close regulation within bracket Amendment Act 2023, which provides for, what is it? Section,
My lord, this is an appellate provisions, my lord.
which provides for an appeal before the appellate authority. Full stop. At this stage, the learned counsel submits that he may be permitted to withdraw this application with a liberty to file an appeal, to prefer an appeal before the appellate forum. He, however, expresses an apprehension that in the meantime, he, however, prays for an interim protection, that in the meantime, the status quo of the land be maintained. Full stop. Para. Considering the above, comma, also heard a long learned
1 to 3.
Learned state council, learned senior government advocate for the state of Arunachal Pradesh. Respondent was 1, 2, and 3. Full stop. Considering the order proposed to be passed, comma, notices upon the private respondents may not be necessary. Para. Considering the submissions advanced, comma, while this writ petition is dismissed, comma, liberty is granted to the petitioners to approach the appellate forum. Full stop. It is further provided that if such appeal is filed on or before today,
Today's, my lord, it's 6th.
on or before, you have a break during 13th to 18th, or the appellate for those are open, I think, on or before 15th of April,
My lord.
comma, the status quo with regard to the plot of land in question be maintained till such
My lord.
filing. The petitioners would also be at liberty to pray for adequate interim order from the appellate authority, if so advised.
My lord, may I request one more word, my lord? My lord, I just
Yes.
mentioned dismiss, my lord. May if my lord pleases dispose of, my lord, because dismiss sometimes the clients, sometimes the clients, my lord.
No, we just clarified that this, while dismissing this writ petition, comma, this court has not expressed any opinions on the merits of the case, and
My lord.
the dismissal is only on the ground of availability of efficacious alternative remedy.
My lord, I'm deeply obliged, my lord.
Item number 3.
May I please, my lord?
Yes.
My lord, here
There's a caveat.
there is a caveat, my lord.
Who's for the caveat?
Yes, my lord.
What is your name?
Ingo.
R. Ingo. Okay.
Yes.
Heard. Three R. Ingo, learned counsel for the caveat who has lodged this caveat in connection with an order dated 5/3/2026 passed by the learned district and session judge from reference authority in ALO reference case number 9 of 2025. The caveat would be heard in the event this court proposes to pass any interim order. Caveat stands discharged. Yes, Mr. Sakya, what is
Yeah,
it?
may I please, my lord? Well, I am challenging here the impugn order dated 5/3/2026 passed by
Yes.
the, my lord, authority, my lord.
Yes.
My lord, online, my lord, reference application filed by the, my lord, the respondent, my lord. Lordship will find the impugn order is page 1119, my lord. My lord, the order passed by the authority, my lord, is, my lord, without, my lord, the impleading us, my lord, as a interested party, my lord, by the respondent, my lord, and even the authority has not, my lord, gone into the fact that, my lord, we are necessary party, my lord. My lord, by this order, my lord, lordship will find at page 1119, my lord,
Page?
page 119, my lord,
Order dated 5/3.
5/3, my lord. May I read, my lord? 119, last paragraph, my lord. Since both the respondents have raised no objection, respondents are, my lord, one is, my lord, Deputy Commissioner, and second is, my lord, NIPCO, my lord. Deputy Commissioner is the collector, my lord,
Yes.
and the NIPCO is the, my lord, acquiring body, my lord.
Yes.
And we are, my lord, interested persons, my lord, we are not made a party, my lord.
Who are you?
I am also, my lord, claiming that land, my lord, which was, my lord, declared under section 21, my lord. My lord, in section 21, declaration was made in favor of, my lord, respondent number, private respondents, my lord. And we have filed, my lord, I will come to that. We have filed objection, my lord, saying that land belong to us, my lord. And we have approached this Honorable High Court also, my lord. I will come to that, my lord. Before that, my lord, since both the respondents have raised no objection, this court hereby dispose of this reference case by quashing and setting aside the impugn order dated 21/5,
Mr. Sakya,
my lord.
this order has directed the district collector
My lord. To,
of so and so to deposit the awarded amount
my lord.
into the account of this office.
Yes, my lord.
Now,
Yeah.
it will be deposited in the account of the office.
My lord.
Now, they are yet to get it.
No, my lord, they have now, just now he said that, my lord, they have withdrawn that amount, my lord.
Withdrawn already.
Yes, may I, my lord?
My lord,
For the
before,
provisional of my lord, I just want to place two documents.
No, we can examine that. There is no question of any stay order.
my lord, why I
We
am,
cannot ask them to pay back.
there is a provision, my lord, procedure, my lord, for recovery of the, my lord,
No,
amount.
recovery can be done, but not on the motion stage.
Yes, yes.
Will
No, we are not, my lord. Kindly see, my lord.
No, see, Mr. Sakya, we'll make an observation that if you are able to make out a case that you are also entitled to the compensation,
My lord,
then it has to be apportioned in appropriate manner.
my lord,
Whatever your share, you need to be paid your share.
my lord.
But why didn't you participate in the proceeding?
My lord, I will come to that, my lord. Because, my lord,
It was of which year?
my lord, the
25. It was going on from 25. You are not aware of the proceeding.
no, my lord, we are not made a party here, my lord.
And that we have understood. You have
My
said.
lord, what happened, my lord?
But the land where you claim your interest, over the said land, there is a case going on for at least 6 months.
My lord.
And you are not aware of this.
No, we are aware, my lord. That's why, my lord, when section 21, my lord, order was passed by the collector, my lord, declaring that, my lord, this Hayang land, my lord, the claimant objection were sought, my lord, and we have filed.
At this stage, we'll issue notice that.
My lord, my lord, for a moment, my lord, what my lord has, my lord, the reference authority has quashed and set aside is, my lord, page 120 is an order, my lord, dated 21/5/2025, which to my respectful submission, my lord, in a, my lord, reference proceeding, my lord, the authorities' power are very limited, my lord.
Where is
This is
5/2025?
page 90, my lord. Kindly see, my lord. 90, my lord. My lord, pursuant to honorable court's order, my lord.
We'll issue notice. Third,
Page, my lord, kindly see page 90, my lord.
no, that washing we cannot interfere today itself.
My lord.
will record your submission. Third, Sri R. Sekya, learned counsel for the petitioners who have put to challenge an order dated 5/3/2026 passed by the learned district and session judge Alu, West Siang District, in reference case number 9 of 2025. First, by the said order, the learned court has set aside the order dated 21/5/2025 passed by the Deputy Commissioner, C. Yomi District, and has also directed for depositing the awarded amount into the account of the office. Full stop. Para. Sri Sekya, the learned counsel, has submitted that in spite of the fact that the petitioners are necessary parties, they were not made parties in the proceeding. And the order appears to have been passed on a concession made by the two respondents, namely the collector and the NIPCO.
NIPCO.
He has also questioned the authority of the court to set aside an order dated set aside the order dated 21/5/2025 of the Deputy Commissioner by submitting that no such powers have been vested to a reference court. Full stop. Para. Sri Sri R. Ingo, learned counsel for the respondent number.
Private respondent.
For the who is the private respondent? For the private respondent has, however, submitted and who has appeared on the strength of a caveat has, however, submitted that the amount has already been withdrawn. Para. That notice be issued, returnable on, we give a date. Tell us a date, Mr. Sekya. Can we have it on 6th of May?
6th May, my lord.
6th May, 6th of May. Mr. Ratan will be. Yes. Sri N. Ratan, the learned AAG, accepts notice on behalf of respondents 1 and 2. 1 and 2. You are for 4 to 11. 4 to 10.
Yes, 4 to 11.
10.
4 to 10.
Whereas Sri R. Ingo, learned counsel, accepts notice on behalf of respondents 4 to 10, who has also filed a caveat, lodged the caveat. Let extra copies be served. Let steps be taken for service of notice upon the respondent number 3 by speed post to TD, steps within 2 days. Put the para. Sri Sakya, the learned counsel, prays for an interim order, which is, however, resisted by the learned counsel for the private respondents, who has already informed that the amount has been withdrawn. Para. Considering the above, it is observed that withdrawal of the amount would be subject to further orders that may be passed in this proceeding.
On 6th May. 6th May.
6th May.
Item number 5 to 16.
Is that connected?
Connected, my lord, almost same, but last item is 16 is a bit different, my lord.
Okay, which one should we take?
My lord, first one, my lord, it will cover most of the.
380.
Yes, 380, my lord.
Okay.
My lord, this is regarding.
Ready for, this is for what?
My lord, this is regarding, my lord,
The stage, admission stage.
yes.
Yes,
For
can we go for final disposal?
Yes, my lord.
We can.
Yes. It was, my lord, tried many times previously. Unfortunately, it couldn't be finished. So, my lord, though the matter file looks bulky, my lord, but the gist is very small, madam. This is regarding the lordship, I have seen the NH 415, which is from Itanagar to Bandadeva Road.
Items 5 to
16.
16.
No.
Yes. 5%.
So, my lord, what happened, my lord, this land was not acquired under any provisions of law, my lord. Under the,
You are the land affected person.
yes, my lord.
You had land.
Yes.
And what is the stretch? Bandadeva to?
This stretch is now package C, which is from after that one, Nirjuli to Bandadeva.
Or Bandadeva to Nirjuli?
Yes.
Lands have not been acquired.
No, it was not acquired. The notification, lordship will see how the land has been acquired by the state.
It has not been formally acquired.
Formally,
They have been dispossessed.
yes, dispossessed by notifications saying that the compensation will be given to the people who are beyond ROW, that is right of way, and where the alignment has been changed. To them, the compensation would be paid. Under that notification, then land was acquired, not under any provisions of law. So, in this case, this viaduct was constructed, which is new alignment. It doesn't go to the old road. So, this road is completed. Beautiful bridge has already been constructed. Now, road is true.
Okay.
In that. So, the state respondent, first of all, they prepared estimate, and it went to a more, means road transport at highway. The compensation which was prepared by the deputy commissioner was approved by the MOD, and it was given to the state respondent, and the amount has been deposited in the account of the deputy commissioner. Now, those compensations were prepared, taking the each individual's amount.
Correct.
Now that has been deposited. Now what the deputy commission from Itanagar to Naharlagan, there's no any dispute. They have already paid. And from Nirjuli to Bandadeva also, most of them have been paid, according to the amount that was calculated in the 2016, Malad. Now, when this new deputy commissioner comes, Malad, the state respondent issues a cabinet note where it says the deputy commissioner should be responsible to verify that compensation is paid properly, Malad. That was the cabinet decision. Now, what the new deputy commissioner does is, according to his beams and fancies, so many notifications, the compensation was, notice were issued that you come to the office from such and such date, compensation will be disbursed. And next day he constituted a new committee saying reassessment of the entire, because there are some discrepancies. Their standing trees are not there. Lordship will see in 2016 it was already acquired. In 2021, how those structures would be there. So what now we have in the application prayed that the money already deposited by the government of India should be paid to us, and we have sought solicium also, 100%. But the petitions we have discussed, we want to forego the solicium part. But otherwise, it will create a lot of Pandora. It will open a Pandora's box and create more problem. If we forego the solicium part, but we say the amount already which has been deposited with the state government, with the deputy commissioner, should be paid to us with interest. That's our case. Now, the stand of the state respondent, the state respondent, the only ground that which they have raised is that it falls under Durpong Reserve Forest. So you cannot claim compensation for Durpong Reserve Forest when the entire from Itanagar to Bandadeva, which all falls under Durpong Reserve Forest, even the civil secretariat falls under Durpong Reserve Forest. You have paid everyone. Now for some individuals, you want that there should be clearance from forest department. Whereas in 2016 calculation, the forest officer, divisional forest officer was one of the members.
of the assessment committee. A new ground, my lord. So what we are saying, you cannot now take that ground, my lord, because everyone has been paid. And that question of having the approval from Forest Department was never a question that was raised earlier in with regard to any of the beneficiaries. Only to some of the beneficiaries that has been questioned. On that count, only the compensation amount is not being disbursed, though it's still lying with the Deputy Commissioner.
Yes.
Of course, we have made a state highway as a party, they are perform a party. We don't have any grievance against them. It's only with the state respondent that also against the Deputy Commissioner alone. We are not, we even agree with the state respondents, but they have already deposited amount with the Deputy Commissioner. That has to be disbursed. That's the only thing the Deputy Commissioner has to do. He cannot keep our money with him for no reason.
Yes, Lord.
And this.
Lordship, so far this road is concerned, this is a highway, Lordship. The existing highway.
No, we are not on those. Amount has been paid to you. It's lying in your office, DC office. And the estimate was done on an individual basis. You just verify whether this individual is the name of this individual in the list. You cannot go for another further verification and whether it is forest land. You have paid to all. Amount is lying with you. Complete this.
Here, Lordship, as per our policy decision, Lordship. If Lordship see the page 34, Lordship.
Yes.
Decision has been taken, Lordship. If land falls under the forest, Lordship, they will not entitled for any compensation.
This decision of which year?
This of 2016, Lordship.
16. Then why? How did you pay to the persons? Have you initiated any recovery proceeding?
Lordship,
the entire stretch,
Lordship,
as per Mr. Tafo, he says that it was under the
Durpong
yes. Reserve Forest.
Lordship,
So was this a consideration for while making payments to the others?
This statement, to me, Lordship, is not completely correct, Lordship.
So have you denied?
Because saying, Lordship, here this statement is made in the Lordship affidavit in reply only, Lordship, not in the main writ petition.
But nonetheless, affidavit reply statements, as you know, are also part of the pleadings.
Correct. That is
but and this kind of money is lying with you. Not a question. The money is not there.
Lordship.
They have lost their land. Maybe they were in possession of forest land, which you do not endorse for even for one moment. But we have paid to the others.
That is the issue here, Lordship, because pay to the others, Lordship. Here, Lordship, this is the road which was constructed long time back. This 60, 70 years back, Lordship. Here only the question is the widening the road.
Widening.
No.
Two lane.
That's not correct.
In fact, no, Mr. Tafo, we have understood. See, widening part is also the stretch is from Bandardeva to Naharlagun. Now they are concerned with the stretch from Bandardeva to Nirjuli. So from Nirjuli to Naharlagun, he has contended that all have been paid. And in fact, many from the Bandardeva to Nirjuli have also been paid.
Yes.
Few have been left out, so they have come to this court. And their contention is that money has been estimated, deposited in the office of the Deputy Commissioner, which is lying, and Ministry is also not denying this aspect. You only wanted to verify their antecedents. You will not verify their entitlement. Yes, that part has already been done, estimate has been made, compensation has been assessed. They are foregoing the solicitation part.
That is the Lordship. But here, Lordship, we are going as per our policy decision only, Lordship. Whether we have
This will not be a precedent.
Whether we have Lordship deviated from our policy decision, that has to be seen, Lord.
We'll say that it will not be a precedent. It will not be a precedent. You cannot cite this for claiming anything else. But money has been paid to you. Why don't you utilize the money? And all have been paid. Few have been left out. This item number 5 to 16. How many of you are there? Single.
Yes, individuals.
Then 11 numbers of persons are there. How many amount? What is the amount total lying?
Mother, here each individual is different, Mother. Here
the total amount, Mr. Tapin.
Lordship, total, because here some.
Otherwise, how much is the roundabout claim for each of the?
Here, individual claim is different, Mother.
Around? How much?
Here.
Item number 10. Item number 5.
5, my lord, 43 lakhs, my lord.
How much amount has been deposited now, Mr. Tapin?
My
From
lord,
the
that-
ministry.
As per Lordship, earlier Lordship estimate Lordship, that was deposited that I am told Lordship.
How much?
That amount Lordship,
My lord, page 41 is there.
How much is the amount deposited?
42 crore 66 lakhs 70,505.
And it is lying now.
Yes.
And this will be amongst the 11 numbers of petitioners.
No,
No,
it
this
will
is not-
include the petitioners.
it's for the entire
Entire.
stage.
The entire stage.
Okay. How much amount is now balance after? Can you just indicate?
No, that part I have to take instruction because I don't have knowledge Lordship.
But Mr. Tafu, are you certain that each of your individual claims
Yes, ma'am. Yes,
would
ma'am.
be
Yes.
equivalent to the
Yes.
balance amount which is presently lying in the office of?
Yes, yes. Yes, ma'am. Because the documents, I have annexed the documents, ma'am.
Then it will not be fair if all have been paid out of this 42 crores or what.
Then just it may be taken up after 5 or 10 minutes Lordship. I'll take instruction
Take
if
the
the
instruction.
money is still lying
Yes,
with
yes.
the government.
Madam, it's not connected with this case, madam. In some other cases where dispute was there, in that government, madam, deputy commission sent us saying that we have a lot of money to pay compensation. That communication was there in that.
See, these are all earmarked.
Yes,
This particular amount has come from the Ministry
yes,
of Road Transport only for this purpose.
yes, madam.
No other funds can be diverted for this purpose.
Yes,
So we need to ascertain two aspects. How much amount was initially given for the entire stretch and how much money is presently lying, if any, and whether it commensurates to their claim.
Claim.
That's all.
Just for you, kindly see my affidavit Lordship.
Yes.
The here Lordship cabinet decision is here Lordship. Page 25 Lordship, my affidavit. Here Lordship, see Lordship.
we have also annexed.
What is the cabinet decision?
Here Lordship,
Dated?
dated Lordship 21st May 2021 Lordship.
What is the?
This is in consonance with the decisions of 2016 Lordship. Here Lordship, the compensation to be disbursed after due verifications by the district administration. District admission shall be solely responsible for any anomalies in this regard Lordship. Because lots of Lordship complaint was there Lordship. Inflated bills and the
So that
structure is-
verification you are entitled to do. But that verification will come only when you are making a assessment for compensation.
Lordship.
Assessment was done, estimate prepared, amount has been paid, and center will not pay amount without verifying. That stage is already over, but still you are entitled to do a verification whether it's an imposter or an actually
Yes.
land affected person to that aspect.
Mhm.
But while, see, we are absolutely in sync, our decision will be in sync with your 2016 and 2021 decision.
Yes.
That there should not be any wrongful payment. You need to pay to the actual person and pay what he or she is deserving. Nothing more than that.
Sometimes Lordship structure is not there Lordship and bills are prepared.
Ma'am,
But part that wrong is on our part only because my
You
officer
have to have adequate check and balance. How you can prevent any misuse and abuse of such process.
has.
You can just come back, okay?
Yes.
After a while. Mr.
Yes.
Yes.
If you can get the instructions, can have it today. Otherwise, you can have it on Thursday or Friday also.
Lordship, today is
Today, if you can have it, it's good.
okay.
Item number 17.
Please, Lordship.
Yes.
Lordship.
Number 17.
Yes, Lordship.
Yes.
Lordship, the main counsel is on the way. Kindly this matter may pass over for time being, Lordship.
On the way from where?
From the trial court, Lordship.
Trial court has become more important than the High Court. Okay,
Obliged, Your Lordship.
but may not be, what is the matter about, Mr. Awam?
My lord, this matter is pertaining to upgradation of my lord status and the pay scale, my lord.
What is he doing?
My lord, they are radio, okay?
They are paramedical assistant.
Okay,
Paramedical assistant.
working where? In various districts?
Health department is
His particular, the individual single ballot.
Oh, one person?
Yes, one person.
He wants his upgradation.
My lord.
Okay.
It should be equipped with the my lord, paramedic team, my lord.
And I've discussed with the department, my lord, in the entire Arunachal, my lord, paramedical assistant, there are only 6 my lord, in the entire Arunachal.
Okay.
Which they are claiming for equity, my lord, similar, the pay hike is totally different, my lord. Other cases, they are different role and responsibility.
Okay, it cannot be held to be at par.
At
Yes,
par,
yes,
my lord.
madam.
Charter of duties, pay scale, everything right from the beginning is different, my lord.
So equal pay for equal work will not
No,
apply in this.
Yes, ma'am.
Okay, let him come, we'll try to have it.
Sure.
Item number 19.
It is complete, it will be posted for hearing.
19, who is the council? Chair, Jammu. None appeals for the petitioner on call, whereas 3 and Long, learned senior government advocate, is present for the state. For Sri Long, the learned state council has also informed that pleadings have been completed and the matter can be listed for admission hearing. List accordingly list for admission hearing on 20th of April 24. Be sorry. Okay, next.
Same.
Item number 20.
Same. Readings are over. Same order.
Item number 21.
Uh, 21, yes.
May I please, Your Lordship?
What is this?
This matter is regarding compensation. On last occasion, learned government advocate took further 2-week time to obtain instruction.
Madam Sangeeta, you have got the instruction?
Yes, Lordship. It seems we have not received the instruction yet.
And madam, you have for my ministry, road transport.
Respondent number 4.
That's one number 4. Who is 4?
May I pray, may I pray that to
Chief Engineer, PW, you are for Public Works Department.
yes,
And madam, MR, PHO, on behalf of Kato. Okay, instructions, whose instructions will be required? Madam, yours?
yes, sir. 2 more weeks may be granted.
What about your instructions is required? You will grant some more time, okay? But to get the instructions, notice was issued when?
It was issued in
Okay, 26 matter, okay. What is your name?
T. Tunka.
Howard Sri T. Tunka, learned counsel for the petitioner, who has informed that notice was issued in this case on 12/2/2026, whereafter on 9/3/2026, further time was granted to the learned state council to obtain instructions. Also heard Miss P. Sangeeta,
yes, sir.
learned state council. Madam, your name? M. Learned counsel for the representing the Public Works Department, and Miss, you please give learned counsel representing the Ministry of Road Transport. Para? Para? Ms. Sangeeta, the London State Council, pays for and is granted further 2 weeks' time to obtain the instructions. Madam, get the instructions this time. List on.
My lord, fix that may be given.
List on. 24th of April. 24 April, madam. But there is 1 week holiday. You can get it still in 24 weeks. 24.
Much obliged.
Item number 30 and 31.
I beg your humble apology, Lordship. I'm appearing for item 19 and 20.
Okay. Should have been here. Okay, none appears Madhiji, huh? Okay. We have fixed it for Mr. Long. We have which key concert India? 20. None appears for her. This is item number. Your item.
30 and 31.
Yes. There is a request for upgrading the item.
30, 31, 32, my lord.
Who is there on the other side?
My lord, in 31, I am for LE container 6 inside.
31, okay.
Yes.
And 32?
30 and 32 are interlocutory applications filed by me, my lord. We are contemners number 4 and 5, and 30 is the main contempt petition.
30. No, 30 is an IA.
IA, sorry, 30.
IA
31, my lord. 31 is the main contempt. My lord.
IA is for?
Sorry,
I for deletion of these 2 respondents from the list of contemners, my lord.
Okay. You want to argue on 30?
My lord.
Yes, who's for the petitioner? You are for the petitioner.
Yes, Lordship, I'm for the petitioner.
Yes.
Leading counsel is having some personal difficulties. Lordship.
Who?
Help me, Lordship.
You should inform Mr. Sharma.
Yes, we are supposed to file objection on your IA, Lordship.
Please come all the way.
If my lord kindly looks at the last order, my lord, 16.3, my lord. That day also, this matter has come up for the 3rd time. Even in the last order, my lord, they had short time. Again, the honorable court was inclined to dispose of the matter, but still we agreed, my lord.
It's 3. 53. 3. Is he there or not? Mr. Parme is there or not? In the
Lordship,
court?
he's not here. He's village, Lordship.
Oh, you should have informed him. And otherwise also on 2 dates, 3/3, this matter was taken up. You took time, then 16/3. Today is what? 6/4. You can have sufficient time. He says that in the order, which is the subject matter of this contempt petition, there was no direction to his clients.
Yes, Lordship.
So you have unnecessarily dragged him to the proceeding. That is his case. Of course, you would be entitled to say something else, but you should have said already.
Yes, Lordship.
My lord, may kindly come to the order in the contempt petition, take up the contempt petition, my lord. Paragraph 12 and 13, my lord. It is very clear.
Is it enclosed to your
in the main contempt petition also? I also, my lord.
page?
At page, my lord.
54.
54 is it starts, and the operative portion is at 58, my lord. That is 58 para 12, my lord. Sorry, 58, 59. At the penultimate paragraph, para 12.
Well, we have read. And who are you?
I am 4 and 5. I am the chairman of the Airport Authority of India.
On that effect, please read 12, Mr. Sharma.
My lord.
Please read 12.
12. Under the facts and circumstances, the court is of the considered view that there is merit in the writ petitions, and according to the district collector, Papumpare district is directed to make a fresh award in terms of the provisions of the Act of 2013, and as provided in the first schedule thereto, including the components such as the market value, solitium, and interest, and additional compensation as contemplated under Section 40, subsection 5 of the Act, less the amount already paid to the petitioners within a period of 6 weeks from the date of receipt of a certified copy of this order. As observed earlier, the collector to take market value at rupees 507 per square meter for making the assessment. At para 13, it is provided herein that in making such an assessment, the district collector shall comply with all the formalities as may be found found necessary in this regard. Once the assessment is made by the collector concerned with the aforesaid time, the same shall be forwarded without delay to the state government for its approval, and the approval should be given preferably within 6 weeks of the receipt of the award. The approval shall then be forwarded to the Ministry of Civil Aviation, Government of India, for arrangement of necessary funds. The ministry shall make the arrangements for funds as expeditiously as possible, and in any case within a period of 3 months from the date of receipt of the approved award. Upon the fund being sanctioned by the Civil Aviation Ministry or the sanctioning authority, the same shall be deposited before the district collector, Papumpare district, Arunachal Pradesh, without delay for the disbursement to the beneficiaries. With the above observations and directions, the petitions are disposed of leaving the parties to bear their own cost. Now, my lord, initial direction is only against the district magistrate Papumpare. Then, after making that award, that will go to the state cabinet for approval, and then it will be forwarded to the Ministry of Civil Aviation for disbursement of funds. Now, we have Airport Authority of India has nothing to do with it because we are not.
Yes, yes. How is he connected? And you are for whom?
I am for elite container 6 and 7.
Who's 6 and 7?
6 is deputy commissioner.
Have you made the award?
Yes. No. Yeah, my lord, I have filed reply. Because during that time, the file was lying before the special judge. So we couldn't able to this one.
No, we are not on the justification. You may have good cause.
Yes.
In fact, we have filed an appeal against the judgment of this amount. So that appeal is pending.
Oh, no, we are only adjudicating the IA, whether there are parties
4 and 5
for which some directions were given to be complied with. Now, what is your name?
J. Maybe.
So maybe you have said that you appear for the deputy commissioner,
Yes.
and due to certain
Yes.
difficulties, you could not prepare the award.
Yes.
So the initial part is also is yet to be complied with.
Yes.
Whether you can implement it or not, that's a different matter. And they have also filed the appeal. But their role, prima facie, there is no role to be played at all. Now, even if their role sometimes can be connected with the Ministry of Aviation, their role will come much later.
Yes.
So how is the aspect of arraigned him as contempt will arise here?
Well, Airport Authority, with all respect, Airport Authority of India is a separate statutory body.
That we know. No, at best, for a wrong understanding, they might say that it may be connected to Ministry of Civil Aviation, which would also not be a proper.
That stage is yet to come,
But that stage is yet to come. You cannot drag them. You cannot drag them.
Even at para 7 of the contempt petition, my lord, they have only there are only grievances against the district magistrate Papumpare.
So we allow this. You maintain your contempt petition against the other less contemners. Okay. Heard. Sri R. Sharma, learned senior counsel assisted by Sri R. Dubey for the applicants. Also heard your name?
Yes, Your Honor, Lordship.
As
Iran.
learned counsel for the respond number for the opposite party number 1, who is the writ petitioner. Who is the petitioner? in the contempt petition. Plus, semicolon, Sri Ratan for,
In this IA, we are.
you know, no, and you are there in the IA?
No, no.
Oh, okay. Tara? At the outset, Sri Sharma, the learned senior counsel, has submitted that this IA, which has been filed for striking out the names of the respondent of the applicant who has been added as respondent number 4, was taken up for consideration on 3/3/2026 when time was granted to the learned counsel for the opposite party to file written objection. Full stop. Such time was extended on the next date, that is 16/3/2026, and it appears that no such objection has been filed. Full stop. Though a prayer was made by Sri So-and-so, learned counsel for the opposite party, to grant further time, this court, after looking into the facts and circumstances, and also and mainly the order, which is the subject matter of the contempt petition, has declined to grant further time. Full stop. The applicant is the chairman of the Airports Authority of India and was arrayed as respondent number 4 in the original writ petition WPC. No.
Contempt petition.
What? What was the WPC what?
455.
455. 455 AP of 2024, which was disposed of on 17/9/2025. It is to be clarified at this stage that it was the post which was made the respondent number 4. 4. Full stop. The aforesaid writ petition was disposed of by order at 17/9/2025, and for ready reference, the operative part is extracted herein below. Page 58, 12, and 13. Sri Sharma, the learned senior counsel for the applicant, has submitted that his client has got nothing to do with the compliance of the direction of this court. He has submitted that the matter which pertained to payment of land acquisition compensation was initially in the form of an assessment to be done by the district collector, whereafter the same was to be forwarded to the state government for its approval, which was to be done preferably within 6 weeks from the receipt of the award. Full stop. The approval was then required to be forwarded to the Ministry of Civil Aviation, and the ministry would make arrangements for the funds for expeditious disposal and in any case within 3 months from the date of receipt of such approved award. Full stop. The learned senior counsel has submitted that in the aforesaid directions, there is no role which is to be played by the present applicant, and therefore he has prayed for striking of the name of his client. Sri So-and-so, learned counsel for the opposite party, petitioner, has, however, submitted that the present applicant was made party as the post was made as the Airport Authority of India, represented by chairman, was made the respondent number? Six. So in the initial repetition be six. Huh?
In the initial, it will be 6.
Six. Para. 3. And Ratan, the Honorable AAG, Arunachal Pradesh, who is present in the court, has also informed that the state has filed an appeal or has preferred a writ appeal against the order dated 17/9/2025. Para. Be that as it may, this court is of the opinion that the direction of this court contained in the order dated 17/9/2025 will not, cannot, sir. This court is of the opinion that the present applicant would not have any role in the aspect of compliance of the direction of this court contained in the order dated 17/9/2025. Full stop. This court is accordingly of the view that there is no necessity of arraying the present applicant in the, as a party respondent in the contempt petition. Full stop. Para. Accordingly, the IA stands allowed and the name of the applicant who has been arrayed as respondent
Number 4.
in respondent number 4 in the connected contempt petition number so and so be struck off.
In the second IA, my lord, the respondent number 5, Ajay Kapoor, is a regional executive director, Northeastern region of Airport Authority of India. He's respondent number 5. There are 2 IAs, my lord.
Okay, same will be the same.
Same one. And he's
number
7 respondent number 7 in the repetition, and respondent number 5 in the contempt petition.
7 in the repetition.
My lord.
Regional executive director.
My lord.
It's 7 hoga. Pehla wala ka will change it. And he was not made a party. Airport Authority of Manila represented by the chairman. Okay. Oh, both eyes can go.
My lord. I'm much grateful.
Deeply blessed.
Item number 5 to 16.
OSIPA, so that the amount is lying with the authorities.
It's lying. So he passed the order.
Close. Also, in item number 16, a small difference, madam. One only thing, otherwise, item number 16, there, the compensation that was already prepared in the 2016, regarding that, only the compensation for land has been paid by the present respondent. He has not paid the compensation amount that was assessed for trees and all that, man. He's saying that now no more trees are there. 2016 it was occurred, 2021, how trees would be there now? But anyhow,
Lane was handed over in 2020.
that may be, but it was acquired in 2016. Acquisition was done in 2016.
Otherwise, this assessment has been done for the land.
Yes.
Why are you sticking to that? I think you let it be covered by the common order.
Yes, madam. Now, there was slight difference. That's why I wanted to point it out. Otherwise, the matter is same.
Go into those factual
Yes,
issues. Again, it will be a problematic thing.
Obligement.
And again, reassessment, the entire thing might come. Whatever has been assessed, you verify their antecedents, who are they?
Yes.
And once their identity has been ascertained, you make the payment.
Yes. And since Lordship, admittedly, this particular lane stage falls under the police department. So therefore, Lordship as Lordship has observed Lordship, it will not be Lordship
It
precedent.
will not be a precedent. And you will not insist on forest clearance only in this case, since the land assessment has already been done, amount has been paid to you. Only for those considerations. Please write. 5 to 16.
Yes, madam.
Please have your seat. The cause of action in these writ petitions being common, the same are taken up for an analogous hearing and are disposed of by this common judgment and order. Full stop. The claim
is with regard to payment of compensation for land which were in the possession of the petitioners. Bereft of details, comma, as per the facts projected, comma, there was an expansion and broadening of the highway from Naharlagun to Bandardewa.
It's actually from Itanagar to Bandardewa.
From Itanagar to Bandardewa. And the present claim is for the stretch from Nirjuli to Bandardewa. Full stop. It is contended on behalf of the petitioners that there was no formal land acquisition proceeding, and on the other hand, a notification dated. What is the date of notification? Notify that compensation will be given to RWW.
29/3/2016, my
29/3/2016. And on the other hand, no formal acquisition proceeding.
No formal land acquisition proceedings. And on the other hand, a notification dated
29/3/2016.
Yes, madam.
Was published, as per which compensation would be given to the land affected persons by the right of way and the new alignment.
Yes.
Full stop. It is this case of the petitioners that they fall within such land affected persons, such affected persons who were dispossessed from their lands under their possession due to the new alignment. Full stop. It is para. Sri Tafo, I have heard Sri P. Tafo, Learned Counsel for the petitioners. I have also heard Sri S. Tapin, Learned Senior Advocate, Arunachal Pradesh. Para. Sri Tafo, the Learned Counsel, has submitted that in terms of the notification dated 29/3/2016, comma, assessment of the compensation was made by the concerned Deputy Commissioner, which district Papumpare? Papumpare. An estimate was prepared on individual basis. Full stop. The same was sent for approval to the Ministry of Road Transport and Highway, which was accordingly approved on date of approval. Then date of deposit, anything?
Yes, Malal. Just
Which was approved, and the
this is letter by letter 8 July 2016, man.
by white communication dated 8/7/2016, and the amount was accordingly deposited in the office of the Deputy Commissioner Papumpare. Full stop.
8 July is actually lawsuit. It is forwarding of the estimate.
Yes. Now, by central government, my lord, moved by 30th November 2016, man.
It is 42.
30 November 2016.
30 November 2016.
It is the specific case of the petitioners that while such compensation has been released to all other affected persons, comma, the same has not been released to the petitioners on the pretext that there was a cabinet decision that the claims were required to be verified. Full stop. The Learned Counsel has, however, fairly submitted that though there was also an aspect of solicium in the claim made, comma, the said aspect would be foregone, and the present claim would be on the amount which has been estimated by the ministry. Full stop. It is contended that on some pretext or the other, the matter was delayed and new committees were formed for fresh assessment and verification, which would not be justified at all full stop. He has submitted that when all other similarly situated persons affected by the expansion and broadening of the highway have been paid, the petitioners cannot be left out, full stop. As regards the stand of the state, the learned counsel has submitted that in the affidavit filed by the respondent 3, it has been contended that the land falls under the Durupong Reserve Forest.
Yes, ma'am.
Full stop. He, however, submits that if that be the case, the entire stretch would be similarly situated, and other affected persons have been paid the compensation, and therefore the same cannot be a reason for denial of the legal entitlements of the petitioners. Full stop. Para. Street as Tapin, Learned State Council has, however, submitted that that non-payment of the compensation is fully justified for more than one reason. Full stop. He has submitted that there was a cabinet decision for verification of the claim, which was purely in the public interest and to prevent misuse of public funds. He has also submitted that the land falls under the Durupong Reserve Forest, and without the approval of the Forest Department, no compensation is liable to be paid. Full stop. He has also questioned that the compensation may not be. He has referred to the cabinet decision dated 21/5/2021 and has submitted that such decision was in consonance with the earlier decision of the year 2016, which is mainly in the interest of public. Para. The rival submissions have been duly considered. Para. It is not in dispute that the petitioners were affected by the expansion and widening of the highway as mentioned above. It is also not in dispute that an assessment of the compensation was done in the year 2016 by the Deputy Commissioner, and an estimate was prepared, which was sent for approval to the Ministry of Road Transport and Highways. The said ministry, via communication dated 30/11/2016, had approved the estimate, which presupposes that necessary verification and due diligence exercise was done. The fact that all other similarly situated persons have been paid the compensation would give support to the present claim of the petitioner, who are admittedly similarly situated, as their names are there in the estimate prepared. Yes. So far as the stand of the state is concerned, that the land falls under the Durupong Reserve Forest, this court is of the opinion that while such a stand would be justified in an appropriate case, in the instant case when the compensation has been assessed and approved by the central government in the Ministry of Road Transport and Highways, and all other similarly situated affected persons have been paid, it would not at all be reasonable to deny the present petitioners from the compensation as per the estimate prepared in the year 2016. This court, however, lays a caveat that the present direction for making the payment would not be a precedent would not be treated as a precedent. in view of the efforts of discussion, the present writ petitions are disposed of by directing the state respondents, including the Deputy Commissioner Papumpare.
I'm sorry, Deputy Commissioner, Capital Complex, Itanagar Capital.
Initially also Capital
Yes.
Complex, would take all necessary steps to release the payment to the petitioners, which however can be preceded by a verification of their antecedent, of the verification of their identity, so that payments are not made to any wrong person.
Yes.
As indicated above, the present direction is not to be treated as a precedent.
The common order.
Yes. Deep level.
Item number 17.
I'm extremely sorry for not being present earlier when the case was called up.
17 which matter?
Malat, this is a case where
You are not similarly situated.
no, it's not the question of similarly situated, Malat.
No,
It is-
unless you are similarly.
No, no, Malat. It is,
equal-
no, no.
equal where-
No, the question is, Malat, I am in the middle portion. Health assistant junior, then health assistant, then paramedic officer, then CHO.
You are health assistant.
I am paramedics. All these were, the pay scale were upgraded. But inadvertently, our pay scale was inadvertently not included in the note sheets, and therefore our pay scale was not upgraded. That is the issue, Malat. It is not that I am comparing with some other post.
Oh, then the case is slightly different.
Yes, it's like completely different.
He's not seeking equal pay for equal work. He's saying that he has not been given the benefit of upgradation of pay which you had given to other.
Lower and upper also.
Have you filed your affidavit?
Yes. The finance department has filed an affidavit. They are only denying that the file never came before the finance department.
No, that's a different thing.
No, Malat,
Now the file can come and you can process and do the needful.
Malat, I am retiring on 31st May this year, Malat.
They will be entitled to whatever.
Whatever petition.
If there is if your entitlement is recognized by this court, whatever is the entitlement, even after retirement, you'll get it.
Get it, yes.
When can you complete the exercise?
Provided, my lord, the parent department, my lord, they
Send
my
the
lord,
file.
send the file. They have to start the process, my lord. Then only, my lord.
But why did you leave out this category?
Malat, can I just?
Just a second. Why did you leave out this category?
My lord,
How many employees?
So there are only 6, and financial involvement is only 59,000 something per year per annum.
Only one of you have come to the.
Yeah, only one has come, but this will have the effect on all the other 5 also. There are only 6 paramedics. Malat.
That we cannot say. It's only a personal. It cannot be in RAM decision. If they take it in RAM, it's up to them. But we cannot force them.
Yes. But
Malad, as per instruction, Malad, I could not file the affidavit, Malad, as per instruction, verbal instruction. Malad, their case, Malad, they have never raised this before the appropriate authority, even directorate level, Malad. That is what the.
Why haven't you filed the affidavit 24 matter?
Malad,
I have.
Your stand would be necessary.
Malad, that's
More than
there,
what
Malad.
AG stand. AG will simply say that it has not come from the parent department.
Malad.
So finance department had not.
Malad, in that case, Malad, it can be. Let them consider, Malad. Otherwise, Malad.
Otherwise,
only
the
notes. The approval comes from your.
Malad, that is there, Malad.
Parent department.
Malad.
They can only consider thereafter.
Only thing, the petition, they have not approached the computer. Actually, it should be initiated from directorate level, Malad. They have not approached the director, Malad. That is why, Malad, their file appears, Malad.
Ganesha. Malad, I have the copy of the notes it's obtained through RTI. Malad, all these notings started from the department only. And even the minister, I have annexed.
They have not
Malad, in my affidavit, in my writ petition, I have annexed a note by the department.
He's not.
It's not
forwarding. This will be slightly difficult for Mr. Tagum to make a response immediately. Because these are not matters of records. Your basis is on which document, Mr. Patil?
May I just, let us come to annexure 615, annexure 14, 1 at page 14, 1-4. This is my initial appointment as health assistant junior. My name appears at serial number 10.
Petitioner is health.
Junior.
Junior.
Then, my lord, at page 17,
yes.
Then I was promoted to the post of health inspector. My name appears at serial number 14 at page 18, my lord. These are all promotional.
11.
This is
22/11/99.
99.
Promoted
as health inspector. My name appears at serial number 14 at page 18, my lord.
Serial number?
Yes, 14. Next page. Then, my lord, I was by annexure 3, page 19, my lord. I was promoted to paramedical assistant on 17 May 2005. My name appears at serial number 3, my lord. And our next promotional post is community health officer. And my lord, at annexure 4, page 20.
You have been promoted again.
No, my lord, not promotion. This is the pay and enhancement of all these post.
Next post is?
Next post is CHO, community health officer. Now, my lord, by this order, all this health assistant, then health inspector, and then our promotional post, page 20, my lord. Page 20.
Into order.
Now, my lord,
Please read this.
page here, my lord, all these posts except us, paramedical assistant, page 20, my lord. In pursuance of cabinet decision dated 29 October 2014 against agenda item number 5 conveyed by CIB says the governor is pleased to order removal of pay anomaly by upgradation of the scale of pay of the post of health assistant junior at par with ANM such and such to such and such, my lord. Then the health assistant senior health inspector from scale such and such, and C, community health officer from existing such and such up to such. But here, our post has been inadvertently omitted. Now, I have annexed that. I have annexed that the initial notes, how our pay scale was. This pay scale was enhanced at annexure 6, page 22, my lord. Here, this is totally a typographical error by omitting. And that is my my case, my lord. I could not have been left out. And this leaving me out is an inadvertent mistake, and therefore the department has also recommended. The honorable minister has also given notes, but then finance has declined because of the paucity of some problems, my lord. So, my lord, my respectful submission is that I need to get equal enhancement of pay.
Benefit of the upgradation.
Upgradation, my lord. Yes, my lord.
Okay. Yes. Okay. Please back.
No. I was not thinking. I'm not. Yeah, last.
May I just inform the Honorable Court, my lord? If there is any anomaly in pay, my lord, we have a committee, my lord, headed by the Chief Secretary, my lord. Pay
Anomaly committee.
Yes, my lord. So this thing has to be, my lord, screened by that committee, my lord. If the question is pay anomalies there, then.
Let the
department will
let the administrative department
process, my lord, and that will have to go to the pay anomaly commission.
And the last also, you see the last part, after honorable ministers noting the file was processed and it has come from.
Yes, the instant petition under Article 226 of the Constitution of India has been filed with the following relief. Please quote the relief at page 11 onwards. Okay. As per the facts projected, the petitioner was appointed as a health assistant junior on 11/3/1986 and was promoted from time to time. On 22/11/1999, he was promoted to the next higher post of health inspector, and subsequently on 17/5/2005, he was promoted to the post of paramedical assistant. The next higher post is the post of community health officer within bracket CHO. A decision was conveyed by the department on 11/11/2014, whereby pay scales of all posts were upgraded except the post of paramedical assistant in which the petitioner is working. Such order was issued pursuant to a cabinet decision dated 29/10/2014. Full stop. Para. Three parties. No, I have heard three parties learned counsel is for the petitioner. I have also heard Sri R.H. Nabam, the learned AAG, Arunachal Pradesh, and Sri T. Tagum, learned standing counsel, health department. Para. Three parties, the learned counsel for the petitioner has submitted that there is no dispute that the post of paramedical assistant is one of the cadre posts, and the next promotional post is the post of community health officer. Full stop. He has submitted that it clearly appears that while considering the aspect of upgrading pay scales, the post of paramedical assistant was inadvertently left out. Full stop. He has also submitted that this aspect has subsequently been admitted by the department, which has also made made communication. Full stop. However, the finance department has raised an objection that due to paucity of funds, such upgradation cannot be made. Full stop. He has submitted that the imputed approach would be in gross violation of the right to equality and fair equality and fairness, and would be hit HIT by Article 14 of the Constitution of India. Para. 3. Nabam, the learned AAG, who represents the finance department, has submitted that the proposal for upgrading the pay of the paramedical assistant was not sent to the finance department, and therefore there was no question of consideration of the same. He has, however, reiterated that the aspect of availability of funds would be a relevant consideration. Sri Tagum, the learned standing counsel, health department, has submitted that though it is a fact that the order dated 11/11/2014 had upgraded the pay scales of all posts, comma, the post of paramedical assistant appears to have been left out, full stop. He has submitted that appropriate directions may be issued for considering the upgradation of the pay scales of the post of paramedical assistant by the finance department. The order dated 11/11/2014, which has been issued pursuant to the cabinet decision dated 29/10/2014, would show that while the pay scales of all posts below and above the post of paramedical assistant in the health department have been upgraded, comma, the post of such upgradation has not been done so far as the post of paramedical assistant is concerned, full stop. There is no justifiable reasons not to consider upgradation of the pay scales of the post of paramedical assistant, and the learned counsel for the petitioner has submitted that such omission appears to have been done due to inadvertence. Full stop. This court is of the view that an exercise for upgrading the pay scales of all posts cannot be undertaken by leaving one post in between, full stop. Accordingly, comma, the writ petition is disposed of by directing the parent department, namely the Health and Family Welfare.
Yes, ma'am.
Health and Family Welfare to
First, madam, is to be routed through their separate director of the family welfare.
Okay. Dispose of by directing steps to be taken for consideration of upgradation of the pay scale of the post of paramedical assistant. Full stop. As suggested by Sri Tagum, the learned standing counsel, comma, let such proposal be mooted initially by the Directorate of Health Services.
Director Family Welfare, Director Family Welfare.
Director Family Welfare to the department, which would accordingly send the same to the finance department for due consideration. Full stop. Let the
Commissioner Health.
parent department. Good. The entire exercise of consideration be done expeditiously and completed preferably within a period of 90 days from the date of receipt of a certified copy of this order. This court clarifies at this stage, Sri Patil, the London Council for the
31/5
petitioner, has submitted that the petitioner would attain the age of subordination on
31/5/2026.
5/2026. Full stop. If the process is not completed before the date of retirement of the petitioner and the outcome of the process is in favor of upgrading the pay scales, comma, the petition, all benefits would have to be given to the petitioner, irrespective of the fact that he has retired in the meantime.
My lord, as I informed the Honorable Court, my lord, we have a pay annual committee, my lord, who decides, my lord, in any issues of the upgradation of pay, my lord. My lord, so once, my lord, the finance, the health department, my lord, they
send it to you.
My lord, yes, they send it to the pay annual committee. Once pay annual committee approves, my lord, then it will go to the finance department for concurrence, my lord. So the matter has to place before the pay annual committee, my lord.
I have to write one line, huh? Finance department. Sri Namam at this stage clarifies that the matter has to be considered by the pay anomaly committee. Let's this court accordingly directs that the consideration be done by the appropriate committee, whereafter the decision be taken.
Obliged, Lordship.
We'll put it in the appropriate part, no?
Item number 22 to
Sir,
24.
Martin, you can take.
22 to 24.
May I please, Your Lordship? Lordship, in this this matter, Your Lordship, earlier the Standing Council of Land Management, Your Lordship,
Yes.
there was a Standing Council for Land Management Department, Your Lordship. Land Management Department, there was a Standing Council.
Okay.
So we have.
Now you
Yes,
appear.
yes, Your
Okay,
Lordship.
so what is yours?
We'll have.
Since 2022, no affidavit from the respondent government.
Yes,
So this matter is pending since
we have appeared
2020.
in the last occasion only. Your Lordship.
Okay, but we grant some time, but you file it, okay?
Yes.
Hearts repeat, this item numbers?
22 to 24. Your Lordship.
24.
You're, Mr. Tafu, you're in all the cases?
No, in item 23 and 24, I'm the petitioner,
And
for the
others?
petitioners.
And Lordship, I am in item
She's the
22,
petitioner in the item
petitioner.
22.
Okay. Hearts repeat Tafu, as well as Ms. So-and-so, learned counsel, appearing for the petitioners in these cases. Full stop. Para. Also heard Ms. P. Sankita, learned state counsel,
Yes, sir.
who has informed that earlier the land management department used to have a standing council, and presently the state council are looking after the same. Full stop. She accordingly submits that some time be granted to enable to seek necessary instructions / file affidavit in opposition. Para. Since these petitions are pending since long, a final opportunity is granted to enable the learned state council to obtain the necessary instructions / file affidavit in opposition. Para. List on, we give a date, madam.
After 3 weeks, Your Lordship.
We'll give more than 3 weeks, but you file it. Today is 6, 1, 2, 3, 1, 2, 3. We'll have it on 4th of May. 4th May.
Obliged.
Enough time we are giving, file it.
Yes.
Obliged, Lordship.
Item number 27.
Yes, Mr. Patil.
My lord, I was served with the copy of the affidavit of R6, and I have filed my reply, but I could not locate him. So
Who's R6?
can we take it up tomorrow, my lord, for disposal? Otherwise, at least I get a chance to serve him the copy.
Lordship, I'm for respondent number 6.
6.
Not
We've been
tomorrow.
trying to contact you
It will be difficult. We'll have it on Thursday.
Thursday, day after,
No, not day after, Thursday.
for disposal, my lord.
We cannot, let's see. I heard 3 T party learned counsel for the petitioner. Also heard 3 Ms. P. Sankita learned state counsel. 3 P. Tafu learned counsel for respondent number 5 and 3
Tiga, Lordship.
T. Galo.
Gao.
Learned counsel for the respondent number 6.
Yes, Lordship.
Para. 3 party the learned counsel has informed this court that though affidavit in reply has been filed, copy of the same could not be served upon the learned counsel for the respondent number 6
May I
as
please
he was not readily available.
Lordship, I have
We just received.
Sri Gao,
physically I have received now. However, Lordship, a scan copy was already received.
doesn't matter. Sri Gao has been, Sri Gao, the learned counsel, has been served with the copy of the affidavit reply in the court today itself.
Yes.
Para. In view of the above, consideration of this matter is deferred till Thursday. List of
It is 9th.
9th.
Received obliged.
9th disposal.
Item number 28.
Yes.
My lord, by the last order, the court directed that this matter can be, if time permits, the matter can be disposed of.
Affidavits have been filed.
Yes, madam.
All has, 1 to 4 has filed.
I'm for this regulatory commission, my lord, three.
Three.
Respondent.
And you are for
Respondent number 4.
private respondent. And Ratan appears for the state.
Yes, madam.
Okay. If you are agreeing, we can take it up for disposal, whichever. What is the matter about? Sudas? What is the matter about?
The matter, my lord, is a challenge to transfer number 4 being appointed as chairman of the regulatory commission, my lord. Now, there are two parts, my lord. But on one occasion, your lordship has said that university has come before your lordship, my lord. Now, so
yes.
So here,
yes, please.
We say that Article 319D attracts Respondent 4 because Respondent 4 that is not denied in the affidavit, my lord. Nowhere in the affidavit they have said that he was not appointed earlier as member of the Arunachal Pradesh Public Service Commission. He remained there. Thereafter, he came up as chairman of this regulatory commission, which was created by an act called 2007, that was Arunachal Pradesh Regulatory Commission Act 2017. Now, the petitioner university was created by an act of 2012. Now, these private institution as well as others, they were governed by 2017 regulatory commission. They regulate the procedure, etc., and all this thing. That is why we say that we are directly, at least, we are an interested party to question the appointment of Respondent number 4.
Your prayer.
Thank you.
Yes, please.
My lord,
Let us have the facts.
now, the question come up before Lordship, my lord, whether as university we can come before Lordship to question the appointment of respondent of post.
You're questioning the appointment of?
Respondent of post.
Appointment of R4 as?
R4 as chairman. He was appointed as chairman, regulatory commission, my lord.
Chairman, Regulatory Commission.
Regular question. Now, next question come, whether Article 31(9)(d) applies to respondent four.
Okay.
That is a legal question, my lord. These are the two short questions before Lordship, my lord.
Okay.
Which are, and the next part is that what are the relief that your Lordship will decide.
Yes.
Now, the first question, my lord, before going to the different decision of the court, my lord, you also will, we have stated in paragraph 2, our read question paragraph 2, 3, 4, and 5. 2, 3, 4, and 5. Who we are. The petitioner university is being directly affected has invoked exterior jurisdiction of the court under Article 12, so and so, member secretary, so and so, so. Next, that Provincial University of Studies is a self-sponsored established under
Your first statement is an incorrect statement, Mr. Das, unfortunately. Paragraph 1.
Paragraph 1.
The petitioner is a
The
citizen
petitioner
of
is a-
India. How are you a citizen of India?
Madam, it is filed by the registrar.
No, it's not filed by the register. It's filed by the university. Register is not a party here. Is university represented by the registrar?
Through its registrar.
Yes, it's represented by the registrar. It's not filed by the registrar.
No.
It's filed by the university. It's not a citizen.
Yeah.
You could have made a registrar a party. You could have made the board of directors party. You can make individuals a party. Nobody has come. So there is no citizen before us. There is a legal person. We are going to examine on the basis of a legal person.
Now, leave it aside that for the time being, my lord. For the time being, your lordship will come to paragraph 3.
3, okay.
That National University Service is a self-sponsored private university established under the University Act 2012, enacted by the Registrar of University and assented to by the law so and so, Bar Council of India, so and so. The petitioner being a permanent institution established and functioning within the state of Arunachal is vitally concerned with the development, regulation, maintenance, and maintenance standard in higher education in the state, which is a matter of paramount public importance, directly impacted the social economic welfare of the people. The petitioner submits that the education institutions are not merely at so and so. Fifth, that the state of Arunachal enacted Arunachal Pradesh Private Education Institution Commission 2017 with the stated object of establishing a regulatory commission to ensure the proper standard of admission, teaching, so and so. Private right of appointment, so and so, itself subject to the so. Now,
yes,
2012, the university was enacted. 2017, the regulatory commission.
Okay.
Now, at this stage, your lords will find that
yes,
whether
yes, please.
any other person, because your lords will just take up these 6 and 7, my lord, paragraph 6 and 7.
Yes, please.
That five number so and so 11(3) to 24 sheets saying on the recommendation of such committee 7324, the Honorable Governor of Assam, saying as the chairman of the Arunachal Pradesh Private Educational Regulatory Commission 2007 for a period of 3 years. That is how he was appointed, madam. That is
Response number?
Response
number?
Annex 1, page 33.
Response number?
4. Response 4.
Please response number?
It's page 33.
No, this setting is response number 1.
Setting, response 4.
R4.
R4.
Appointed as chairman.
Annex 1.
Page 33.
Page 33.
Chairman. Okay.
The next paragraph, you will make it clear about it. These are the short locations.
Yes, yes.
That the petitioner begs to state, place on record that she is saying, that is responsible for. Presently, chairperson of Regulatory Commission was former member of the State Public Service Commission of Odisha during the period 13 to 17 to 12 to 23. That is at annexure 2. बोला annexure 2 पेज कितना है? I think it's annexure 2, page 42. Page 42. Page 42. At the bottom, Madam, original footage. Mr. Sering Nakasa, 13 to 17 to date of appointment, date of completion 12 to 23.
Yes.
Then now, basically,
Now this tenure has been completed.
yes, basically that is the
No, the tenure is over.
His
No, tenure is over in 23.
No, he
Extended.
No, Manoj, what has happened, Manoj? There is another story, Manoj. APSC, there was a big scam and etc. Then the matter went to Supreme Court, Manoj. And while the matter was there in the Supreme Court, he resigned.
This is the tenure of his being a member of the State Public Service Commission. Presently, where is the appointment as chairman of this committee, of this regulatory committee?
Then,
it's 33.
After his tenure as a APSC member, Manoj, he was appointed here as regulatory commission, the chairman of regulatory commission.
Okay. Okay. For 3 years. This is for 3 years. Appointment was for 3 years.
Yeah. Okay. Now, this is the brief position with the case, that earlier he was a APSC member, he resigned, and then he came to be appointed. Now, whether the question is that we say that Article 319 D attracts, he could have been appointed to any other state except the state of Odisha Pradesh. That is Article 319 D, Mala. D. Okay.
Yes, please.
Manoj, now, the question before Lordship, Manoj,
Yes.
A person holding an office without legal authority, my lord, who can question it?
No, no, first, what is the violation? What is the violation? Where is the violation of 31D, 319D?
Yeah. No.
Yes.
Let us go to the locus today, my lord.
No, locus will come. First, what is the violation? Let us overcome for the instance.
319D.
D. Where is the violation?
Yes, my lord. The first decision, my lord, that is
No, first, let us read the state. Let us read the constitution.
the
319D.
319.
How is it violated?
Yeah.
319 is prohibition as to the holding.
319 is start with prohibition as to the holding of office by members of commission on ceasing to be such member.
Okay, there is no dispute that this R4 was the member of the State Public Service Commission from 17 to 23. No dispute with that. So he was earlier a member. So the prohibition will lie where? Under D?
Now,
on ceasing to hold office.
On ceasing to hold office.
D, what is D?
A member other than the chairman of a state public service commission shall be eligible for appointment as the chairman or any other member of the Union Public Service Commission or as a chairman of that or any other state public service commission, but not for any other employment either under the government of India or under the government of the state. Or under the government of the state. That is, he could have been eligible. He could have been.
Okay, we'll come back at 1 o'clock. 2 o'clock. Okay. We'll require your assistance, Mr.
Yes, ma'am.
Yes, please. Yes, please.
My lord, we just remember, my lord, that he is appointed by the government, by the state, and the pay and allowances are paid by the state. There is a lease between him and the state government. That is a character, my lord. That will be important.
Let us see the act at page 43.
Yeah. My lord, to understand 3190, my lord, there are two decisions, my lord, which I am placed. One is Alok Kumar Sengupta, my lord. Here, paragraph 1, 2, 9 and 10. That is 2018 to Jharkhand, my lord.
There are other decisions also
Madam,
on the aspect of
and,
employment. What is an employment?
Yeah. The paragraph that is, my lord, will be relevant. 1, 2, 9 and 10.
1, 2, 9 and 10.
9 and 10. Next, my lord, is argument pan.
Yes.
That is Supreme Court, my lord.
Hmm.
Full bench decision, my lord.
Yes.
That the paragraph, my lord, 1, 2, 3, 5, 6, 7, 8, 12.
1, 2, 3.
5, 6, 7, 8, 12.
That governor's case. Governor's case.
Governor. But that case, my lord, though it doesn't squarely fit here, my lord, that gives an explanation to Article 319. That, my lord, first of all, my lord, this first case which I want to take your lordship, my lord, that is all of Kumar Sankutra, my lord. Your lordship may kindly paragraph 1 and 2, it gives a shortly, my lord, the facts of the case, my lord.
Yes.
Paragraph 2, scorn of unnecessary details. The facts as has been delineated in the writ application is that the petitioner was in a state judicial service and retired on 31/1/2009 from the post of district and session judge, Wada. That the petitioner was appointed as member of the Jharkhand State Public Service Commission by notification dated so and so person thereto. The petitioner gave his joining on the state post. Subsequently, the state government by notification number so and so was pleased to appoint him as acting chairman of the Jharkhand Public Service Commission. And according to the petitioner gave his joining to the post on session. The petitioner demitted the office of the Jharkhand Public Service Commission on so and so after attaining the age of 62. It has been stated in the application that by letter so the petitioner was informed that he was nominated as first register of the newly established National University Studies so and so by the Honorable Chancellor. In person to such nomination, the petitioner discharged the office of the Register of the Law Enforcement. That the petitioner was nominated as one of the member of the State Police Complaint Authority by notification number so and so. In view of the said notification, the petitioner tendered his resignation so and so. His resignation being accepted by the complaint authority was duly communicated so and so, issued by the register so and so. The State Public Complaint Authority has been constituted by the state government by resolution dated so and so in view of the direction by the state by the Honorable Supreme Court in the case of so and so.
Yes.
With regard to the police reform in the state of so and so. To the utter surprise of the utter surprise and consternation, the nomination of the petitioner for the post of the one of the member of the Police Complaint Authority was cancelled on the ground that his nomination is contravened to Article 319 of the Constitution of India by the so. That is the case, brother. That is how it is. Now we come to paragraph 9, my lord.
Yes.
Paragraph 9. The service of the petitioner as member of the State Public Service State Police Complaint Authority has been cancelled by invoking under Article 319 of the Constitution of India. It would be opposite to refer to 319 of the Constitution, which is quoted here and there. 319D. A member other than the chairman of the State Public Service Commission shall be eligible for appointment as the chairman or any other member of the Union Public Service Commission or as the chairman of that of any other State Public Service Commission, but not for any other employment either under the government of India or under the government of a state. The bar of Article 31D of the Constitution pertains to member chairman of the Public Service Commission to hold any post under the state level after demitting the office. On perusal of the resolution relating to the state police complaint authority, it is quite apparent that a state government is competent to nominate the member of the state police complaint authority to refer function from time to time to the state committee and to remove any independent member of the state committee, and thus the state police complaint authority is under the control of the state government. Therefore, holding of the office by the petitioner as a member of the state police complaint authority is violative of Article 319 of the Constitution. Accordingly, his nomination by the member of the state police complaint authority has been cancelled under provision of Article 319 of the. So far, decision cited by the learned counsel for the petitioner so and so to Hargwed Pant, the word employment. Now we do not want to, that is, we'll go in details, my lord. So that is how 319D was explained, my lord. Now we come to argument part, my lord. Here, my lord, what has happened, my lord? This, he was the governor, my lord. So the court said that the full bench decision, my lord, governor and the judges, they don't come under the state employment. That is how it was distinguished, my lord. This petition was especially petition is directed against an order made by full bench of the Rajasthan High Court dismissing the petition filed by the petitioner for causing and setting aside an order of reversion passed against him by fourth respondent in his capacity as acting vice chancellor of the University of Rajasthan. The order of reversion was challenged on several grounds, but they were all negated by the full bench, and the writ petition was dismissed on a preliminary hearing. The petitioner has raised some same ground of challenging in the special leave petition, but bearing one ground which calls for a reasoned judgment. We do not think there are any other ground which requires detailed consideration, and we reject them in limine. The only ground which need to be considered and which we propose to dispose of by the judgment is a constitutional one, namely whether the appointment of the first respondent as governor of Rajasthan is valid. This question becomes material because if it is found that the first respondent could not be validly appointed as governor of the Rajasthan and his appointment as governor is invalid, he would not be chancellor of the Rajasthan University and he would have no authority to appoint Rajasthan number 4 as acting vice chancellor so university. But the impugn order of reversion made by him would fall. We are therefore called upon to consider in this SLP whether the appointment of first representative as governor of Rajasthan is valid. The only ground which the validity of the appointment has been assailed is that the first representative was a member of the Rajasthan Public Service Commission during so and so period, and he was therefore, by reason of Article 319D of the Constitution, ineligible for employment either under the government of India or under the government of state. And since the office of the governor is an employment under the government of India, the first representative could not validly be appointed to that office. This ground raises a question of considerable importance relating to the applicability of Article 319D to the office of the governor. We shall have to consider the true nature of the office of the governor in order to determine whether it is an employment under the government of India. But before we do so, we may first have to look at Article 319. The article consists of A to D, and
And these clauses on a combined reading imposes prohibition prohibition on holding of the employment under the government of India or the government of a state by the chairman or member of the Union Public Service Commission or a state public service commission on his ceasing to be such member, such chairman or member. This prohibition has been enacted enacted in public interest with a view to ensuring that no allurement is held out to the chairman or member of the Union Public Service Commission or a state public service commission, which would deflect them from the path of rectitude and duty. The Union and the State Public Service Commission are charged inter alia with the duty of advising the government on various matters relating to civil service and civil posts, such as method of recruitment, appointment, promotion, and transfer and disciplinary matters, and it is of utmost importance for the efficiency and integrity of the civil service, and this duty should be performed by the Union and the State Public Service Commission objectively, impartiality, and without being influenced by any external consideration. The Union and the State Public Service Commission have vast power of recruitment to an immense and increasing post of the government post, and in a country with considerable employment, these powers may be prone to abuse if the office of the chairman and a member of the Union and the State Public Service Commission is exposed to executive and political pressure. The prospect and peril of the executive and politicians try to influence overtly or covertly the chairman and the member of the Union and the State Public Service Commission by dangling the carrot or holding out the possibility of employment under the government after the expiry of their term or office may corrupt the integrity of the institution and Union and State Public Service Commission. It is true that by and large, the chairman and members of the Union and State Public Commission would be men of proven merit and integrity, and no eludement howsoever attractive would deflect them from doing their duty without fear and favor. But even so, the possibility of obtaining employment under the government in future may consciously or unconsciously influence them to fall in line with the wishes of the executive or the politician. The office of the chairman and member of the Union Public State Public Service Commission must therefore be jealously kept beyond reproach and above suspicion. It is pointed out as far back in 1924, the Royal Commission of the Superior Service of the wherever democratic institution exists, experience has shown that to secure an efficient civil service, it is essential to protect it as far as possible from political or personal influence and give it that position or stability and security which is vital to its successful working as impartial and efficient instrument by which government or whatever political complexion may give effect to the policies. In countries where the principle has been neglected and where the spoil system has taken its place and inefficient and disorganized civil service has been inevitable result and corruption has been rampant. 3. It was a result of this recommendation that a Public Service Commission has set up in the country with the objective of outlined by the Lee Commission when the Article 285(3) of the draft Constitution providing for ineligibility of the chairman and members of the Union and the State Public Service Commission for future employment under the government was being debated in the Constitutional Assembly by Assembly. Dr. Ambedkar pointed out the reason. Now, I come to the other important matter relating to the employment or eligibility for employment of the members of the Public Service Commission, both the Union Union and the State Public Service Commission, members shall see, according to Article 285(3), we have made both the chairman and members of the Central Public Service Commission, as well as the chairman of the State Commission and the members of the State Commission ineligible for reappointment to the same post. That is to say, once a term of office of the chairman and member is over, whether he is a chairman of the Union Commission or the chairman of the State Commission, we have said that he shall not be reappointed. I think that is a very salutary provision, because any hope that might be held out for reappointment or continuation of the same appointment may act as a sort of temptation which may induce the member not to act with the same impartiality that he is expected to act in discharge of the duty. Therefore, it is a fundamental bar which has been provided in the draft article. Five, it is therefore clear that a constitution maker were anxious to insulate chairman and member of the Union and State Public Commission from the executive or political pressure or influences, and to place them beyond the reach of any allurement or temptation which may cloud their judgment and deflect them from doing their duty. The constitution makers were keen to ensure that the chairman and the members of the Union Public Service Commission were above reproach, free from coercion and political influences, and could, if necessary, stand up against the executive and defy any political pressure. It was with this end in view that constitution makers enacted Clause A to D of Article 319 prohibiting future employment under the Government of India or under the Government of the state or chairman and members of the Union State Public Service Commission. 6. We are concerned in this SLP only with Article D of the 319, which since the first respondent was a member of the Rajasthan Public Service Commission, and it is on account of that fact that it is claimed that he is ineligible to be appointed governor of the Rajasthan. Clause D of 319 provides, on ceasing to hold office, a member other than the chairman of a State Public Service Commission shall be eligible for appointment as a chairman or any other member of the Union Public Service Commission, or as a chairman of that or any other State Public Service Commission, but not for any other employment either under the Government of India or under the Government of a state. It is therefore obvious that the first respondent could be appointed chairman or any other member of the Union Public Service Commission or chairman of the Rajasthan or any other State Public Commission, but he was ineligible for any other employment either under the Government of India or under the Government of the state. Now, it was not the case of the petitioner that the office of the governor was an employment under the government of the state, and the only question which therefore requires to be consideration is whether the office of the governor can be said to be employment under the Government of India. Now, while explaining, my lord, Article 319, then it goes to the facts of the case, my lord, because that was the question where the governor was. He was the governor, and that was the question. Otherwise, had he not been the governor, then the case would have been different. This Article 319 would have been applied. So in this case, madam, what we're going to, firstly, the honorable, the full bench, my lord, they went to the object of the debate of how it was, how 319 came into consideration, because earlier it was 258 came into consideration, why it was enacted. Then thereafter, my lord,
they have decided 319D. Validation. So, with regard to in this case, my lord, we can just stop it here because we have only found that what is the object of 319D and whether it attracts another. We say it attracts it attracts the petitioner respondent in this case because earlier he was a member of the State Public Owners of Public Service Commission. Now he is appointed as chairman of the Regulatory Commission, which, my lord, there is a lease between the respondent and the state. He is under the employment that is receiving pay and allowances. And all
2017 Act.
Madam?
2017 Act, let us see that Act.
17 Act, madam. You also, that I have quoted in my definition also, my lord. Just one. Madam, kindly take, before going to the act, madam, kindly take page 11 of my writ petition, my lord, paragraph 9.
Yes. Yes.
Paragraph 9. Therefore, a ready reference the petitioner seeks to refer to the provision of the Regulatory Commission 2017.
You have also enclosed, I think, at page
Yeah, the whole
42, I think.
the only
33, 42. What is that?
to show that a commission is a body that comes under the terms commission as provided under 319 of the Constitution. The act is named as the Universal Pradesh Private Educational Institution Regulatory Commission Act 2017. Section 2 defines commission means regular. Section 2B defines member. Member means member of the commission and includes the chairperson. Section 2D defines regulation means regulation made by the commission under section 19 of the section 2E defines regulatory body means the state or the central body set up for the purpose. Section 2H defines what prescribed means. Prescribed means prescribed by the rules made under the act. The act thus expressly contemplates that the crucial details concerning its operation, including the manner and process of appointment, qualification, procedure of selection and condition of service of the official of the commission are to be regulated through the rules framed under the authority of the act. This legislation intent is clear that no appointment or exercise of power under the act can be effectuated in vacuum without rules. Section 3 provides establishment of commission. The state government may by notification published in the official gazette establish the ownership Pradesh Private Educational Institution Regulatory Commission for the purpose of providing a regulatory mechanism in the state and for working as an interface between the state and the central government regulatory bodies for the purpose of ensuring appropriate standard of admission, teaching, examinations, research, extension, so and so. The commission shall be a body corporate having perpetual succession and common seal, so and so. The headquarters of the commission shall be at Section 4 provides composition. The composition consists of chairperson and 2 other members from among the person of eminent public life or in the field of higher education or who have remained secretary or above the government or above to the government or owners of or held equivalent post in the government of India for a period of not less than 3 years, provided that a chairperson and a member shall not be from the same field of specialty. The chairperson and members of this commission shall be appointed by the state government on the recommendation of the search committee for a period of 3 years or until or she attains the age of 65 years, whichever is earlier, and such chairperson or members may be eligible for a period of subject
to the upper age limit also there, provided that after the expiry of the term of office of the chairperson or member of, as the case may be, shall not be eligible for further employment.
Have any rules been framed, Mr. Das? Under the act, have any rules been framed?
So,
Because under section 18,
18, yes.
there is a power to make rules.
Yeah.
And if you come to 18(2)(a), without prejudice to the generality of the foregoing powers, such rules may provide for all or any of the following matters, namely A, terms and conditions of service of their chairperson, the members and the secretary of the commission.
Yeah.
Are rules framed or not? Not framed.
No, rules not made. Rules made.
Rules made, not made.
Not made. We have stated that the rules have not come.
So what are the terms of the chairman?
Mala?
What does he receive? Does he receive any salary?
No, that I.
If he's not receiving any salary,
In the affidavit filed by respondent number 1 and 2 at paragraph 11, they say that it is in the process. Rules are in the process. It is not yet.
no rules.
No. Paragraph 11. Respondent.
So there is no
So there.
statutory recognition of any salary being paid.
There is another aspect you also just say in the act, there is a coercive. Of course, Madam, that is only to take note of because that has not, we have only stated, Madam, that coercive action would be taken by the chairman and the members. Now, there is a decision of the Supreme Court. Madam, that is section coercive action. Coercive action क्या होता है कौन सा सेक्शन ना वो तो फान है ना नहीं देखा तो क्या करेगा वही है ना पावर ऑफ फंक्शन कमीशन टू टेक इनटू प्रिजन पेनल्टी वाले कहाँ है
Penalty is 11. It is not for the chairperson. It is for the commission.
paragraph 11 मान लो
11 commission.
Yeah.
Commission may for contribution of commission may take.
Now, what I meant to say, in the Supreme Court, that I have already in my rejoinder affidavit, I have given that that the non-judicial person, they cannot sit over and act as judicial authority. That was decided by Supreme Court in an arbitration case, where the
but this is from
I'm giving a reference to that, how they are proceeding with it. It is not that, we have not challenged that. But the question is
even otherwise, this act does not confer any judicial powers.
No, yeah. But here, only what the petitioner here, would like to show, that
yes,
that Article 319D squarely attracts in this case. Squarely attracts in this. Now, going back again to
and the aspect of employment would come. Employment would necessarily require payment of any allowance, salary.
Yeah.
That is not there.
That is in Indian appointment order. Appointment order. They have annexed the appointment order. Affidavit है ना? Affidavit है ना? Appointment order. You also will find
33 of the writ petition.
uh, in the affidavit filed by respondent 1 and 2 at page 67.
No, at least 33 of a writ petition also, appointment offer letter is there.
Page 67.
33.
On the recommendation of search committee, that is dated 15th search committee of the Arunachal Pradesh Regulatory Commission, the governor of Arunachal Pradesh is pleased to appoint sharing so and so respondent for commission at a revised pay scale of this 2,000, 2,50,000, 25,000 per month, so and so admissible. The appointment is for 3 years, expiry so and so. And further.
Yes.
No, my lord. I've got 2-3 reasons about that location. My lord, let me complete that location. I'll be supplying this season, my lord. I have got only one copy.
On what point?
The first section is, my lord, 1959, Air 1959, Punjab 83, division bench, my lord, Bindra Ban and others. 1959, Air 1959, Punjab 83. The paragraph 4, 6, 7, 8 and 9, my lord. 8 and 9.
Give the paragraph of
8
the
and
findings only. All may
nothing,
not be
my lord.
necessary. Give the paragraph where findings are there.
I don't, without reading it, my lord, don't have it. The next, my lord.
This is on what point?
My lord.
On what point?
That is on locus today. Locus today.
Okay.
Locus today.
Yes. Rejoinder has been filed today. You filed the rejoinder today?
Yeah, I filed one. There is no legal point, my lord. Nothing actually. We have just.
We've been served copies.
Definitely. Got it.
Yes. Okay, that's all.
My lord, there is another Supreme Court decision, my lord. AIR 1962 SC 1044. Calcutta, the Calcutta Gas Company. Paragraph 3 and 5. Madam, where I'm just reading a sentence. The right that can be enforced under Article 226 also shall ordinarily be the personal or individual right of the prisoner himself, though in the case of some other writs like habeas corpus or quo warranto, this rule may have to be relaxed or modified. That is it. Short another reason.
Yes.
Another decision, that is Himachal, that is a division based decision, 2003 2 CLJ ASP Himachal Pradesh 451. Arvind Sharma versus State of Himachal Pradesh. That is paragraph 24, 26.
Please give the citation again.
24, 26.
Please give the citation again.
Citation 2003 2 CLJ ASP, that is Himachal Pradesh, within bracket 451. Arvind Sharma versus State of Himachal Pradesh. That is division based decision. Paragraph 24, 26, 30, 31. 31.
On locus.
From all these cases, you also will find, all right, if you take a strict view, my lord, who can come before lordship, my lord? Even a person, that is a hell. Even a person who is a taxpayer, they can also, because in one of the question, your lordship find that the question the appointment of Advocate General was challenged. But who is he? He is a auditor. That was said that yes, it comes because he is holding a public post. The person is holding a public post. So if he is Whether he is rightfully holding according to law or not, that can be questioned by a taxpayer. That are the strict cases, my lord. Okay. So my humble submission before your lordship, my lord, that in my represent, my lord, I have set out my case. There is only two issues which I say that one is whether 319D attracts in this case or not. The respondent filing that is all 1 to 4, my lord, although they have filed separately, but they have taken up the plea that only on locus standi. They did not challenge the appointment of respondent number 4. That sticks because that is a rightly on record, my lord, they cannot do it. So only they have said about that locus standi. The locus standi which I have said, my lord, that even if strictly because I am an interested person, the petitioner here, because there I am appointed as under article under the Act of 2012 and 2017 they regulated me, so I definitely come as an interested person in this case, whether to see whether the person who is regulating the institution are rightly appointed or not. But in spite of that, my second leg of argument that there are 4 or 5 decisions of the High Court and Supreme Court, my lord, they say that even all other persons can come. That is my whole submission before your lordship. In case a reply is required,
Yes, yes, we'll come back to you.
So, lordship. My lord, facts are undisputed, my lord. The private respondent, number 4, he was earlier a member of the Arunachal Pradesh Public Service Commission. And he resigned. Now, he has been appointed as the chairperson of the Arunachal Pradesh Private Education Institutions Regulatory Commission under the Act, my lord, of 2017.
Note Karina.
Article 319D also prohibits from employment under the state government. May I read again, my lord?
Yes.
Article 319D. A member other than the chairman of a state public service commission shall be eligible for appointment as chairman or any other member of the Union Public Service Commission or as the chairman of that or any other state public service commission, but not for any other employment either under the government of India or under the government of a state. Now, the term employment, my lord, this is the moot question whether the present post of chairman or chairperson of the Arunachal Pradesh Private Educational Institution Regulatory Commission is a employment. That is the moot question, my lord. Now, my lord has seen the act. They have a fixed tenure. It is undisputed that the pay is also given by the government, my lord. And the appointment also is made in the name of the governor. But whether this can be termed as an employment under the state, my first submission will be that this is not an employment under the government of Arunachal Pradesh, my lord. It is an appointment under a statute. This act provides for appointment of chairperson and members of a commission. It's an appointment under a statute.
Yes.
And they have their own, under this statute, the commission the chairperson and the members as a commission, they have their own powers and functions. And these powers and functions are not directed or dictated by the government. They have their independent powers and functions. So the duties, the powers and functions of the commission of the private respondents, it is independent of any control of the state government. It's a totally independent function, my lord. Now, that is the sort. Now, only the term employment, whether it can be interpreted in a narrow manner or in a larger perspective, my lord. My lord has, my senior has already read out the decision, has referred to the decision of Hargobind Pant's case, my lord. My lord, I have come across the decisions of Karnataka High Court and as well as the Punjab and Haryana High Court. My lord, these are appointments to the post of Information Commission and also the member of the Lokayukta. Same facts they were earlier, the public service member of Public Service Commission. Now, I may furnish this first. I'll just border only one statistic. And this is with regard to Chief Information Commission, my lord, Commissioner. I'll directly take your lordship to the second last page. This is printed through Supreme today, my lord. It's Karnataka High Court, my lord. Second last page, my lord, is with regard to the appointment of Chief Information Commissioner.
Yes.
Para 11.1, my lord. Therefore, the question that arises for our consideration is whether the office of the State Chief Information Commissioner or the State Information Commissioner is an employment within the meaning of that expression in Clause D of Article 319. Semantically, the word employment is not a word with a single fixed meaning, but it has many connotations. Connotations, my lord. Sorry, my lord. On the one side, it may bear the narrow meaning of relationship of employer and the employee, and on the other, it may mean in the widest connotations any engagement or any work in which one is engaged. If the former be the sense in which the word employment is used in Clause D of Article 319, the Office of State Information Commissioner would certainly not be an employment because the State Information Commissioner of a state is not an employee or a servant of anyone. He occupies a high constitutional office with important constitutional function and duties, my lord. Here, my lord, this private respondents occupies a statutory post, my lord. It will be seen from this enumeration of the constitutional powers and the functions of the State Information Commission that he is not an employee or a servant in any case of the term. It is no doubt true that the Information Commissioner is appointed by the governor, which means in effect and substance by the government of Karnataka, but that is only a mode of appointment and it does not make the Information Commissioner an employee of or servant of the government of India. Every person appointed by the governor is not necessarily an employee of the government of Karnataka. If therefore the word employment would certainly not be an employment within the meaning of Clause D of Article 319. But if we accept the wider meaning of the word employment as connoting any engagement or any work in which one is engaged as the expression self-employment, the Office of the State Information Commission would clearly be an employment within the meaning of Clause D of Article 319. However, the Office of State Information Commission is not an office of profit, and the same is not subject to the control of the government of Karnataka. We are therefore of the considered view that the Office of the State Chief Information Commissioner and State Information Commissioner is not an employment under the government of Karnataka, and it does not come within the prohibition of Clause D of Article 319. On careful consideration of the materials on record in consonance with the relevant provisions of the Act and the Article 319 of the Constitution and the dictum laid down by the Apex Court in Hargobind Pant's case cited supra, we are of the considered view that there is no illegality and capriciousness in the decision that the governor, while making appointments, so and so. My lord, basically, here, even if the salary or pay, even if it is given by the paid by the government, and the appointment is made in the name of the governor, that two criteria will not automatically make any appointment a government employee. An employment under the government that will not automatically make the payment mode and the appointment mode. What my respectful submission will be, whether the powers and functions to be exercised by this appointee is independent of any control of the government. That will have be the criteria to see whether this is an employment in the under the government of under the state government for the purpose of Article 319D. That is my respectful submission. I'll not bother with regard to the entire act, my lord. In the entire act also, powers and functions are given, my lord. In section 9. I have another citation, but I'll not bother. That is for appointment of a local member. Okay. That's all, ma'am. No question.
Your Lordship,
Here for the
for responding number 3 matter.
commission.
Commission matter. Since this learned advocate general has addressed the core issues, Your Honor, Your Lordship. Only regarding this locus standi minor, a locus standi in our affidavit minor, in opposition minor, where clearly said he has no locus standi. as a university.
Year for respondent number 4,
Three, my lord. Three, my lord.
commission.
Commission, my lord. And the judgment that our learned, the senior judge has placed regarding co-warranto, my lord, on irregularity, my lord, actually, it might be this body, statutory body, university, but it is not a person. And regarding
It is a person, it is not a citizen.
yes, ma'am.
It is a person, legal person it is.
Yes, ma'am.
It may not be a citizen.
My lord. And another, your lordship, this repetition suffers from this inordinate delays and latches, my lord. This appointment was made as big as in this 11 March 2024. And this gentleman, this Mr. Register has come here in the December 2025, my lord. And,
2 years.
yes, my lord. Almost after 2 years, my lord. And that too, my lord, prior to this, my lord, I would like to bring into the record of this honorable court that actually there are personal grudges between the commission and this university, my lord, and numerous litigation has been initiated in this court and ordinate benches. And your lordship, 2 repetition, I think, are still pending, filed by them, my lord. And there has been, they are aggrieved by the action initiated by this commission under section 8, my lord, pertaining to those issues are in session by this honorable court, my lord, in other repetitions, my lord. So what we submit is, my lord, locus standi and delay and latches and personal grudges, my lord. On those grounds, my lord, it is a pit case to be dismissed, my lord. Your lordship, some this repetitions is still in session.
What are the numbers?
My lord. WPC 531, my lord.
Subject matter?
Subject matter is, my lord.
531 of 25.
25, my lord. Subject matter is, my lord, section 8 of this act, my lord. Section 8 of this act empowered me to raise fund for my individual existence, my lord. Section 8 of the act, your lordship may come to this repetition, my lord.
43.
My lord. My lord, page 45, section 8, fund, my lord. The commission shall establish a fund to which shall be credited by the private educational institutions' percentage of total fees every year as may be assessed by the commission from time to time, but not exceeding 1% of the total fees. Any other grants received from any other source and all sums received by way of penalties. So we have been resorting to section 8, subsection A, my lord. So this petitioner and some other, basically one more university, they are defying our order. And we have this particularly under this chairmanship of this private respondent number 4, my lord. Some drastic issue process has been initiated against the department, my lord, or this petitioner university, my lord. Only after that, my lord, as a we can say countermeasure, my lord, they have belatedly filed this writ petition in 2025, my lord, March, almost after December, almost after 2 years, my lord. So personal grudge may not be a ground to maintain this, my lord, this writ petition, my lord. And co-warranto, my lord, of course, seeking co-warranto might be good, but actually It is doubtful, my lord, whether as a university he can, my lord. It is doubtful, my lord. Because in the judgment cited by him, it has not been said any institution, my lord. Any institution that has been cited in the citation presented by our learned senior, my lord.
Kindly come again, not understood.
Co-warranto, of course, writ of mandamus and are different from this status. This is different from habeas corpus and this co-warranto, my lord. So locus standi, my lord, are basically different. Section 2, Article 220, under 226, this co-warranto can be issued by any person without having this, even having personal this injury, my lord, provided the person is holding in the public office, my lord. That is clear, my lord. But our submission is that whether as a university he can come against the this private respondent pleading for this co-warranto, not as a, because nothing is affecting him actually. Nothing is, this appointment is not affecting the petitioner in any way, my lord. Because for the, he is saying, I am being governed by them. Let him so. If I am governing him, till today, what order he has complied. Let him so, my lord. On the other way, he says, your governance over me is illegal. That's why I am challenging Article Section 8 of the Section 8 of the Act as alpha virus.
It's a division bench.
No, my lord. Not in division bench, my lord. It is in single bench. Single bench, my lord.
Well, yeah, virus is challenge. It has to be a DB, I think.
My lord. No, my lord. It was in this. If I'm not wrong.
Of
yes, he says it is. No, my lord. It is single bench, my lord. Single bench, my lord. So on the in the repetition, this 531/2025, he says it is alpha virus, and that's why he is not this agreeing to us, not being governed by us. And under this repetition, he is saying, my lord, I am being affected by his appointment. So he cannot blow cold and hold together, my lord, for same issues, my lord. That's why, my lord, for this contradiction also, this repetition is fit to be dismissed, my lord. I'll remain, my lord. Repetition is, my lord, 531, my lord.
Yes, please come this side.
May I, my lord? My lord, I have a small submission, my lord, regarding the maintainability of this instant writ petition, my lord. Firstly, my lord.
What is your name?
R River, my lord, River for private respondent number 4.
R River for R5.
R4, private respondent number 4.
Oh, yes.
My lord, firstly, my lord, to maintain a writ petition, my lord, there must be a injury of the personal right of the petitioner, my lord. Or secondly, my lord, it should be for public interest. But here in this case, my lord, firstly, there is no personal infringement of right of the petitioner, my lord. He is a legal entity, my lord. He has nothing to do with the appointment of the member of the commission, my lord. And secondly, my lord, this writ petition come up when after the petitioner, they have denied our order, my lord, for levying of 1% of their annual, my lord, annual income they have generated from the student, my lord. That they, therefore, my lord, this writ petition is not on the public interest, therefore, my lord. This is for private malice, my lord. My submission would be, my lord. Therefore, my lord, this writ petition deserves to be, my lord, dismissed, my lord. For that, my lord, I like to bring my lord to the page number 86 of my affidavit, my lord, filed by affidavit filed by private respondent number 4.
Given today.
Page number?
86, last page, my lord.
One page, okay, one file. 86.
Yes, my lord, last page, my lord. This is, my lord, someone issued by the, my lord, Arunachal Pradesh Private Educational Institution Regulatory Commission, my lord, on their failure to comply our order, my lord. This is, my lord, this is someone, my lord. It was issued there after repeated, my lord, notice they have failed to deposit the 1% of their annual.
Which one? Page?
Page number 86, my lord.
Order dated?
Dated 26/12/2022. This shows that, my lord, they have been refrained from following our order, my lord, repeatedly, and when they did not get concession on this 1% charges, my lord, they filed this writ petition maliciously. This is my submission, my lord. And lastly, my lord, I'd like to submit that this commission is an independent statutory body, my lord. Therefore, the Article 319 does not, this commission doesn't come under the purview of Article 319. This is my only submission, my lord.
Yes.
This is only my.
Anything?
I just want to bring out two decisions, madam. One, that APSC matter that earlier, as I have said, madam, that is Arunachal Public Service Commission matter that went to Supreme Court, madam. That is 2025
Why is it necessary?
why it is important? Paragraph 84, I'll be read it off.
What is there?
Your lordship may take down the reference, madam. I'll be subject to air 2025 Supreme Court.
Yes.
5103, paragraph 84, I think.
The name of the case?
74.
Name of the case?
Yeah, I'll just 74. In addition to the aforesaid, it is necessary to say that after the leakage of the question paper for main examination came to light, the state made a reference to the inquiry committee. The chairman and fellow members of the APSC submitted their resignation on moral ground and for other reason. Later, Major so-and-so and was sworn in as State Chief Information Commissioner of Arunachal Pradesh, and Mr. Sering, that's 104, was appointed as chairman of the Arunachal Pradesh Private Education Institute. If the members of the APSC who were allegedly collectively found involved in the paper leakage as so later resigned and got assignment of new state of a new post by the state, it is a question to ponder upon, which ought to be looked into by the state, especially so when Article 319D of the Constitution of India bars members of the State Public Service Commission from taking up any other employment either under the government of India or under the government of the state after they cease to be in office. This is what. That is what it was remarked. And that is how it was done. Now, I'll और क्या है ना क्या है बोलो ना क्या है डिले लेसेस में बोला है डिले लेसेस में डिले Now, regarding delay, laches, malice, and motive, my lord, that has been taken care of by a division bench of Allahabad High Court. Regarding malice, motive, which has been argued, and the delay, my lord. This I am referring to, my lord. That's all, my lord. और कुछ बोला है तो आप बोलिए.
Just clarification with regard to the reference case by one of the members of the Public Service Commission. And that was before the Supreme Court. All other members, they resigned voluntarily on moral grounds, but there is nothing against them. There was nothing against them. So the findings, whatever, there is nothing against the members of, only on moral grounds. They had resigned.
I'm not. I'm not imputing anything, my lord. I'm only bringing it how that is duration in APSC, how it came to an end. That's all. Nothing more than that. Nothing more than.
We'll close it then.
Nothing more. Only a reference to the notice of the court. I'm not even. That is it. But the other decision which I have said, but regarding delay lessons and all that, I'm relying on, my lord.
Okay, heard.
My friend, he wants to say something. But
No, we don't hear two counsel. Senior counsel is already.
I don't.
For one party, we hear only one counsel. Yes. Heard three. D.K. Das, the senior counsel, assisted by your name? Your name?
No, that is already.
D.K. Das.
No, your name.
A.D. Verma.
A.D. Verma for the petitioner. Also heard Sri N. Ratan, Learned AAG, State of Arunachal Pradesh. Sri Jammu, the learned counsel for the commission, respondent number 3, and Sri Riba, R. Riba, learned counsel for the respondent number 4. The hearing is concluded, the judgment is reserved. We'll consider all the things. You have to. You don't take two files here. Normally you for separate file. No, if you do it, fine.
Sometimes we have
You keep all the headings together. One line work. Pass on that one. Just a minute. Okay, yes, yes. Yes.
Number 29.
Service upon respondent number 2 is still limited.
This one. Yes, what is it? Service report in respect of
Respondent.
R2 is still awaited. When did you take steps?
My lord, step was
12/2/2026. More than a month has passed. Who is respondent number 2?
respondent number 2 is principal man
Of
of government high secondary school Nyapin.
Government High Secondary School.
Yes, ma'am.
Education Department perhaps can take the notice. Government Council, Madam Sangeeta.
We should get this Standing Council for Education.
Education. Can you have somebody? Who's there? Tagum.
Yes, Taratagum.
Where is he? Is he around?
He was here earlier.
Please try to. Oh, this is a contempt petition.
Yes, madam.
Oh, contempt needs to be served. We thought it's a writ petition. You have to take fresh steps then, okay?
Okay, ma'am.
One has been served.
No, one was, my lord, not necessary. Only step was taken upon only respondent number 2.
As per the order of the court.
Yes, my lord.
You take fresh steps. We
Okay.
thought it was a writ petition. Produced the office notes dated 25/3/2026 and 4/4/2026, as per which service report in respect of respondent number 2 is still awaited. Full stop. Office note dated 12/2/2026 reflects that the notices were dispatched only on 12/2/2020. Notice was dispatched not only, but dispatched on 12/2/2026. Full stop. Since sufficient time has elapsed and there is no certainty of the service and the present petition being for alleged contempt where the consequences are penal in nature, so let fresh steps be taken for service of notice upon the respondent number 2. Steps be taken by speed post with AD within 2 days from today. List on 4th of May, along with service report. You take fresh steps.
Okay.
Also one matter, item number 4.
Please, my lord. My lord, there, I filed an IA also for amendment of the cost title because there, in place of Public Works Department, respondent number 2.
First, we dispose of the IA, okay? Heart Street D. Soki, Learned Counsel for the applicant who has filed this IA for making, praying for making a change in the description of the respondent number
2 and 4.
2 and 4. Full stop. It is submitted that though the cause of action is against the Public Works Department, by mistake, comma, Rural Works Department was written in the
Respondent number 2.
only in 2.
For respondent number 2, it is rural works was written. And response number 4, otherwise it's a tender matter. The department itself had in the NIT, they had wrongly mentioned as ALO. So we have, but subsequent.
What did you say? Department was written against response number 2.
True.
Full stop. He has also submitted that there is some discrepancy which in the description of the response number 4, which has been corrected, which has been sought to be corrected by means of this IE. Full stop. Also heard Ms. P. Sangeeta Leonard, State Council, who does not object to the same. Full stop para. Considering the above and the nature of the amendments paid for, the instant IE is allowed. Full stop. Petitioner is required to file amended cost title in the writ petition. I stand disposed of. Would you like to move the writ petition today itself?
Yes, my lord, there's urgency.
Yes.
My lord, this is with regards to tender matter, my lord. Here, my lord knows that in this state, my lord, there is an act, my lord. That is District-Based Entrepreneurs and Professionals Act 2015 is there. That act was for the equitable distribution of the work so that the uniform social and economic society is formed. And under that act, there is a power for framing of rules, and accordingly, rules have also been framed, which were in 2015. Then rules were subsequently amended in 2018 because there was some ambiguity in the 2015 rules. More particularly in Rule 4E. Now I will take your lordship immediate directly to the rules. It starts at page 32.
Where did the State Council go?
He called to, went to inform the AAG, Mr. Ratan. Page 32 it starts, man. The typed copy is at page 34. The act otherwise it's applicable to all the government departments.
Yes.
Page 34, my lord, and relevant portion would be page 36, my lord. This is Rule 4E, my lord. 4.2E, my lord. Sub Rule 2 close E, my lord. Page 36, my lord.
In the larger
in the larger interest, yes. In the larger interest of the public and for equitable distribution of developmental works amongst eligible contractors, and also to ensure effective management and quality of works, a contractor shall be allowed to have only 2 works in hand in any of the departments under government of Arunachal Pradesh at a time, and for which he shall make a declaration to be executed in an affidavit that he is not engaged in more than any 2 tender works under the state government. He shall also, for participation in any tender, be required to submit completion certificate issued by the engineer in charge, duly countersigned by the concerned superintending engineer and chief engineer. Now, my lord, there was some ambiguity, my lord, regarding the number of works that can be awarded, my. So, which was subsequently cleared at page 37, my. This particular rule was amended, my. 1/8/2018, my. This is a notification, my, and amendment is at 2, my, serial number 2, my. In the Arunachal Pradesh district-based entrepreneurs and professionals, so and so, under clause E of sub rule 2 of rule 4 in existing entry, the following entry shall be substituted. Namely, in the larger interest of public and for equitable distribution of developmental works amongst eligible contractors, and also
3.
to
It has been increased to 3.
3. At the best 3, and at the time of participation of the tender, he can have 2. So that the third work can be awarded. So at the time of participation of the tender, at the most, he can have 2.
So there is no amendment as such.
This is, otherwise earlier it was 2 in hand, and at the time of participation also 2. So there was some conflict, man. Now it says
Shall be allowed to have only 3 works in hand.
Yes.
Department and
at a time, instead of existing 2 numbers of any tender work under the state government and for which he shall make a declaration to be executed in an affidavit that he is not engaged in more than 2 tender works under the state government. Meaning hereby the third tender would be the tender in which he is participating. So maximum 3 works basically.
There's no ambiguity as such.
Earlier it said 2 works in hand, and then at the time of maximum 2 works, and then at the time of participation also 2 works at page 36. Be that as it may, now it is hence corrected to 3 works.
Contractor shall be allowed to have only 2 works in hand in any department unless at a time for which it's a declaration. Okay.
Yes. Now, my lord, this IFB invitation for bids was issued, my lord, for construction of school, my lord. Page 38, my lord. Here, name of the work is there, my lord. This was issued on 16/3/2026. So in
16/3, what is the date?
16/3/2026.
Yes.
Now, in response to this, my lord, 4 firms participated, my lord, including the petitioners and the private respondent, my lord. Now, since these are from the same locality, my lord, the petitioners are aware of the number of works the private respondent is carrying on. He has already 3 works at hand.
Including petition and R3.
Petitioners has already 3 works.
No.
My lord.
The respondent, who is the respondent, private respondent number?
Private respondent number 5.
5. So there are 4 participants, including the petitioner and R5.
Yes, ma'am.
R5 is having
R5, yes. R5 has already 3 works. Now he has been declared as the L1. Now we have raised objection also. We have filed our representation also. That our representation starts at page 39, man.
Yes.
Page 39, man. This we, because at the time of opening also we objected, and subsequently, after taking out this RTI application also, page 39 this starts, man. Page 41 is the RTI application, man. Reply, man.
Page
41, man.
What is that?
This is the information furnished by the department, UD, man. Details, this is under the urban affairs, ALO division. 1, details of ongoing works of measures Benji Loma Enterprises under UD and Housing Department, ALO division. This is serial number 1, if your lordship will see in the table. He is already constructing ongoing works, construction of multi-story parking lot at ALO. Number 2 is construction of 12 type 2 residential quarters for fire and emergency service at ALO. These are 2. And third work is by the Yomcha division itself.
Where?
Who has next page, my lord. This work was awarded in February 2026 itself at page 42, my lord. We have filed an RTI information also from the Yomcha division, but the department it is still 42, my lord. 2 measures, Benji Loma Enterprise, the respondent number 5, my lord. Letter of acceptance of the work, construction of girls hostel at Donji Polo, Government College, West Chang District, AP. And down below, my lordship will see 26/2/2026, man. Just 1 month back, man. So he has 3 works in hand. Now we submitted this application, and then after that at page 44, if you lordship may come to page 44. It's not very legible, so the type copy is at page 45. This was on 28/3/2026, man.
Yes.
To the superintending engineer, ALO civil service, construction of so-and-so, the work, my lord. Sir, with reference to the work cited above, in the above subject, enclosed, please find here with the letter by so-and-so, proprietor of so-and-so. Whereas 3 so and so sought cancellation and disqualification of measures Venji Loma, who is the private respondent number 5, and so on the ground that both the firm has 3 and 2 works in hand respectively, which according to his letter is a violation of the clause 4.2e of Arunachal Pradesh district-based entrepreneurs and professionals rules 2015 white number so and so dated so and so. Serial number 2. This is also important because it is a part of the tender document also, tender condition also. However, clause 2 of Rule 4 of the Arunachal Pradesh district so and so rules 2015 has been amended by number so and so dated Itanagar so and so, which clearly states that the contractor shall be allowed to have only 3 works in hand in any department instead of 2 numbers. This amendment is in agreement with clause 30.
We have read this. You contended the respondent number 5 already has 3 works.
3 works.
So he could not have been eligible to participate in the present IFB.
Man.
And therefore he being adjudged as L1 is illegal.
Man.
That is your case.
Yes, that is my case. Because this is in violation of, because tender conditions also says that.
What is the present work?
Malad?
What is the work about?
It is for infrastructure development of government upper second primary school at Peri Kamki.
Okay.
So this approval for
You are found to be technically feasible.
Feasible. These petitioners are L2 and L3.
Oh, 2 petitioners are there.
2 petitioners are there. We want that it should be according to that. Now, as of now, Malo, this letter was on 28th.
You are having a conflict of interest. How do you join together?
Well, we
You are
just
competitive.
competitive, but we want that the department will decide who will be awarded the work. It should be.
You could not have joined together. It's a bad strategy. You can file 2 petitions, no problem.
Of that, of course,
Because you have a conflict of interest. Tomorrow, suppose R2 is not given, 3 is given. R2 may have a cause of action. If you don't have a cause of action, it will show that you are a cartel.
No, my lord, we are because they want that the rules and the tender conditions should be implemented. That is all.
Normally, R2 would have been the best candidate
yes.
to challenge.
Of course, that I understand.
Yes, madam.
Your Lordship, I'm extremely sorry, Your Lordship. The conducting counsel, Mr. R.H. Nabam, he was supposed to appear, Your Lordship.
But he has moved it. We have to pass some orders.
Yes.
What is the stage now?
My lord, we could not locate the department. They have gone in hiding. But as of now, this approval
Can go in hiding.
the officials, my lord. Officials, even we have to take this because we took the photograph from the SC office. So this is also not very clear, the annexures, my lord. This approval was given on 29th of March, my lord. So and it has in the approval order, 15 days have been given
What is
to
the
for
tenure of the work?
tenure also 1 year.
1 year. Okay, madam. Really short notice. Don't ask not to go ahead with the work. Heard Sri D. Soki, learned counsel for the petitioners who have put to challenge the outcome of a tender process initiated by IFB dated 16/3/2026. Full stop. It is the case of the petitioners that there were 4 bidders, including the petitioners and the respondent number 5. Full stop. Respondent 5, in which the respondent number 5 has been declared as the L1. The L1 or what? L1.
Respondent 5 years, L1.
The primary ground of the present challenge is based on the rules, give the full name, on the Arunachal Pradesh district based entrepreneurs and professionals bracket incentives, development and promotional bracket close rules 2015, which were framed as per the Act of 2015, full stop. The rules have also undergone an amendment in the year 2018 with regard to Rule 4 within bracket small Roman 2 bracket close within bracket small e 4(2)e. Please check. Full stop. It is contended that as per the unamended rule, And as per the present rule, rule 4(2)(e), comma, a contractor shall be allowed to have only 3 number of works in any department under the government of Arunachal Pradesh. Full stop. It is the specific case of the petitioners that the respondent number 5 already has 3 numbers of works under the state and therefore was ineligible to participate in the IFB. Full stop. It is also contended that objections were raised and representations have been filed which have not been acted upon. Para. Let notice be issued. Returnable on raise fixed on 24th. Okay, returnable small short date 24th. Ms. P. Sangeeta Learned, State Council accepts notice on behalf of respondent numbers
1 to 4.
1 to 4, 1 tier 2, 4. Extra copies. Okay, right. Steps for service of notice upon the respondent number 5 be taken by speed post with AD. Steps by tomorrow. Para. Sri Suki, the Learned Council for the petitioners praise for an interim order. Full stop. Upon considering the facts and circumstances and also considering rule 4(2)(e) of the rules which restrains participation in a tender process by a bidder who already has 3 number of works, comma, it is directed that no further steps be taken for execution of the work covered by the IFB dated 16/3/2026. Para. It is however made clear that since this order has been passed at the motion stage and ex parte qua the QUA, italics, qua the respondent number 5, comma, the respondent number 5, the respondents may come up for modification, alteration, if so advised. Modification, alteration, vacation.
Item number 32 and 33.
But the notices were issued on 9/3/2026. Office note indicates, but in respect of this item number 32, 4 and 5 is still awaited. Now the office note is not clear whether in respect of the other respondents, notices are returned.
2, 3, 4 and 5 were issued when 18/3. 18/3, we need some time.
Yes.
Why has it been listed today? Reported returnable or what?
Yes.
Returnable today.
Returnable, yes.
Your Lordship, I am appearing on behalf of the respondent Loma Kurdu and the Junior Standing Council for the responding authority, that is Itanagar Municipal Corporation. Okay. And Your Lordship, yes, copy of the petition yet to receive.
Okay, your respondent number?
All the respondent.
All the respondent?
Yes.
No, madam, up to 4, I believe.
Private respondent, perhaps you cannot be.
Yes.
Mayor also, perhaps he will not be able to. Mayor is an elected representative. Yes. Mayor, if he takes, it's okay.
Yes.
Okay, 5. Only 5 will remain. 5 will say await
Yes,
service
5.
report.
Yes.
Will heard 3D Panging Learned Council for the petitioner who has referred to the office note dated 4/4/2026, as per which service report upon respondent numbers 4 and 5 are still awaited. Full stop. Sarah, your name, please.
Your Lordship, Wayan Tamin.
Please write. Learned Council appearing on instruction of
El Kurdu.
Al Kurdu?
Junior Standing Council of
Junior
IMC.
Council?
IMC.
Itanagar Municipal
Yes.
Corporation accepts notice, submits that he will be accepting notice on behalf of respondables 1, 2, 3, and 4. Full stop. In view of the same, let extra copies of the writ petition be served upon him by tomorrow. Sarah, list this case on 27th, by which date fresh service report in respect of respondent number 5 be given by the office.
There's an interim order.
The official respondents may also obtain the instructions by the next date. Sarah, interim order passed earlier stands extended till the next date of listing.
Obliged.
Your Lordship, item number 33, Your Lordship.
33 is connected. No orders are required to be passed.
Okay. Obliged.
Mr. Panging, 33, you are not there in 33.
No, my lord, I am not.
Is it connected? Your colleague is there. Why is it tagged together?
Connected basically in the sense where issues are different. Only the IMC is same.
So,
respondents.
How is it connected?
That's right.
Issues are different.
Issues would be different. This is also regarding termination, but our ground is totally different. Item number 32. Grounds will be totally
In your case, but it's with we don't write. List along with. Don't write anything. It'll be along with. Not okay. No order. Don't pass on it. Okay. You can point it out on the next occasion. If you want the segregation, we can segregate it.
Okay.
We can do it today itself.
Yes, why not?
Yes.
Okay. Your name?
T. Game, Your Lordship.
33, right? You are not on record, Mr. Game. On behalf of whom?
On behalf of petitioner number, in case number, writ petition 114 of
No,
20.
your name is not there. Is your name there in the Wakalatnama?
Yes.
Okay. Why is it not reflected in the copy? Heard 3T Game Learned Counsel for the petitioner. Well, let me see the file. इसमें होगा ना? Yes, इसमें. We have. We have not taken steps.
Oh, Your Lordship, what happened
It's
here?
not dated 4/4/2026.
Your Lordship, what happened here in this case, Your Lordship? This court has directed me to take the step within 1 week, Your Lordship, and within 1 week I've served the notice to the register. But Your Lordship, today I approached to the register and ascertained whether the step has been taken or not. Then they returned me the notice, Your Lordship, and they said that the case number is wrongly reflected. So I corrected rectified the case number and resubmitted my notice.
Office note dated 4/4/2026 reflects that steps for service of notice have not been taken. Full stop. Sri Game, the Learned Counsel has however clarified that those steps were duly taken, comma, there was some mistake in the case number, which he has rectified today.
Yes, yeah, today.
Office to proceed accordingly and accordingly for dispatch of notice. List on same date will give 27 along with service report.
Yes, Lordship. Obliged.
Item number 34.
Hearing, but
Hearing will not be possible. Mr. Singh, you've been sitting for long. Which matter? Hearing.
there's also hearing.
Tender matter.
Not be possible. But today we thought I did not expect that this will take so long. Many matters have been disposed of, that is why.
Yes.
And last matter took a long time.
Yes.
University matter. You can have a date of your convenience.
After 2 weeks, madam.
So give a date, see if you come for.
I have.
You're in both the matters.
You have both the matters.
Then this one.
For
Yes,
in item 34.
34.
for the respondent.
And 36 is FCI.
FCI, my lord. Tender matter, my lord. There is stay by this honorable court.
Oh, stay is also there. So FCI we can have when?
On
Next Monday or
next Monday.
Next Monday is a holiday.
Okay.
28th.
This Friday? If you're in
Friday, I can.
Friday.
Last working day, my lord, I don't know.
If your lordship is sitting, then we can
No,
have it on.
this court will not be there. This court will not be
So
there.
on 28th, my lord.
21 को कीजिए
21st
मैं को इसको छोड़ के आएगा ना
Will
second half में होगा.
will our will brother
पे छोड़ के हॉस्टल में
will our esteemed brother Kardec who has any difficulty in taking up 36? Then Friday we can fix because he'll be available. Now there are a few matters he cannot take up. That is why I'm asking. If we fix and he cannot take up, then no point for Mr. Singh to come. On Friday?
If
Or
your
it is
lordship is not there, then let it be on some other day, my lord.
Okay. And 35, 34? 34?
after the Binu break, man.
Okay, will give us a same date, huh? Please write, huh?
27?
Possibility of time will not permit
On 20.
taking up of this matters, taking up of this one, huh? Of this matter today. Full stop. On request, list on
27.
27, man.
27. Please write the name.
BK Singh.
Now, in 34, you write, now write the name. So, D. Panging for the petitioner, P and state, P. Sangita for the state council, and Sri P. Tafu for the respondent number 5. And you write in 36, same D. Panging for the petitioner, and Sri BK Singh, standing council FCA.
In 36, my lord, there's an interim order, my lord.
Interim order path failure to continue till the next date of listing.
27.
Same date, 27.
Obliged.
Sorry, we would have taken up your case, but there will be no time. Can look at it.